It is July 4th of 2026, and this is the Court Gallery. Today, we're diving into the moments that make the U.S. legal system so fascinating. First, Judge Simmons is not amused when a defendant's reason for noncompliance involves an out-of-state trip for a Bible quizzing tournament. Then you'll see Judge Perkins deliver an unforgettable life lesson to a defendant he once personally offered a job to, who is now back in court and out of excuses. And finally, watch as a lawyer passionately argues the First Amendment itself, trying to convince Judge Gauthier to reconsider a crucial ruling. We're celebrating the United States' 250th anniversary with 250 minutes of pure court content. And it all starts right now.
This is the City of Lansing versus Aaron Jenkins Jr.
This is the public defender Justice Rob on behalf of Mr. Jenkins. I have not seen him physically this morning, Your Honor, but he did say that he was in the waiting room a little while ago.
Someone is in the waiting room now. I'm trying to listen to the team. That's fine. I'm not Jody. Kelly just said he was in there and she was in the room over here. Oh, okay. He was in the long room. Looks like Mr. Jenkins has joined us.
Yes, I am here.
Okay, very good. On the record in the matter of the City of Lansing versus Aaron Jenkins Jr. 25-03337. Appearance, please.
Elizabeth Kirkland on behalf of the City of Lansing. This is the public defender Justice Rob on behalf of Mr. Aaron Jenkins, who is here via Zoom.
Okay, Mr. Jenkins was scheduled for a pre-trial today. This is for operating while under the influence. How are we proceeding?
The city would request that any potentially mitigating documents or reasons be shared with it. There was one that was briefly shared, but other than that, I believe we need a second pre-trial for negotiation.
Second pre-trial.
Or a next pre-trial, Your Honor.
Another.
January 26, 2026. City wants assessment or mitigating documents. Reset it for March 23rd. Where's the mitigating documents? Have they been provided? Because I'm not resetting it for that. Because if you can miss court and then you follow up with me on the 23rd to ask for permission to travel to Florida, you should have done what you were supposed to do in the last 7 months.
My understanding, Your Honor, is that Mr. Jenkins has faced some financial hardships. He did lose his job as a result of this incident, and he is a single father. And so I think that the biggest hurdle is simply financial. I do think that he would like to be compliant based on conversations that I've had with him. And he is, I think, planning to go to Crystal Ray this week.
He had a pretrial in January.
Yes.
It's going to be July this week. This is not a situation. And then he came in March and requested permission to go to Florida in May. This is not an issue of finance. Crystal Ray was available to him in January. It was available to him in February. It was available in March. It was available in April. It was available in May. Available in June. This is going to be set for the next available court date. He needs to appear in person. It needs to be resolved. I'm not extending this out another 30, 60 days. He's had all the time he needs at this point. And I'm setting it for a final pretrial and a jury trial.
May I speak at all?
Not at this time.
Okay.
July 20th at 8:15 will be a final pretrial date. August 3rd at 8:15 in person for a jury trial. Both of those next court dates, you must appear in person. There's also an expired meter that you failed to pay. It says that you owe $96. That's on TV 22003970. And this is an expired meter from 2022.
Mhm.
What are you paying that?
I don't owe that. I went to the court to fight it. They told me that I would have another court date to deal with it, which never happened.
Who was that?
When I went to the parking meter people back in 2022.
The parking meter people did not handle your dispute for a parking meter.
They 2022
Nor
I
do
went
they-
in there.
Nor
Okay.
do they set court dates. I have here, you had an original charge for an expired meter on March 23rd, 2022. On April 20th, 2022, it was filed with court notices and penalties was stopped. It says here on 2023. It says that you owed money. It was for a Chevy vehicle parked. And an
Yeah,
expired
I
meter.
recall it.
There was a parking citation printed and mailed, it says, with the citation date on April 26, 2023. And then you failed to appear on May 15th, 2023.
That is incorrect. That's not correct, Your Honor.
You appeared to the court on May 15th, 2023.
I don't know nothing about the date because that was 3 years ago, but I do know that I went inside a place and told the manager there, and they told me that they will get a hold of me and that they're going to give me a court because I told them it happened on that date. Because I literally had walked out of the bank right there where I was parked at. The lady was trying to give me a ticket as I was walking into my vehicle, and I had people in my vehicle. And she tried to give me a ticket. I said, ma'am, I wasn't getting that ticket. I said I came in and out. And I said that I'm leaving. And then she threw the ticket at me.
I'm hearing what you're saying. All of those things make it clear to me that you were parked at an expired meter and you thought that because you had people sitting in the vehicle and that you were leaving, that absolves you from a ticket, and it does not.
Okay. Well, that's why I was trying to go to court regarding it, and they never got a hold of me to give me a court date.
Well, court date was mailed. It says it here in the judicial information system that it was printed and mailed on the 26th of April, 2023 to the address of record.
Okay. And I never received that. I don't know how I'm supposed to move forward when I don't receive the ticket that was supposedly mailed to me.
If you are requesting a court date and you don't receive it, then you should probably follow up with the court. It shouldn't be 3 days or 3 years later and you think that it just dissolves. It does not dissolve. And so this parking ticket, notices were sent and generated. There was also default notice that was sent to you and generated. And then a penalty was added. So, and a 14-day notice was generated. And so you've not responded to anything. And so you now
I went in and spoke with the. Okay.
You now owe $96.
And there's nothing I can do with it, even though I went and spoke with them multiple times.
There's nothing you can do. You're beyond the time frame. It's 3 years later. There's a certain time frame in which you can fight something or even appeal something, and you have blown all of those time frames.
But I went and spoke with them countless times and asked them to do it. And I've never received the mail, ma'am.
The court speaking to them, you're talking about speaking to people at a parking office. That has nothing to do with the court. Like zero things.
And
So once the court once the court gets involved,
I'll pay it.
you get a notice generated and you didn't respond to the notice. That notice did not come back to us non-deliverable because they would have noted it. His address changed, it was a change of address, whatever, it would have came back non-deliverable. That didn't happen.
Okay. I just said I never received it, but I'll pay it, ma'am. I don't know what else I can do about the situation. That's fine. I'll take care of it.
When are you gonna take care of it?
I'll take care of it.
I'm sorry, I can't hear you.
Here it is. I didn't even notice it. Still, I thought it was done and over with when I talked with the manager because they said they was going to get a hold of me. I apologize.
Of course, it would only come in and he says that again. Whenever you were telling us when you were gonna pay, your signal went out.
Oh, I'll pay today and I apologize.
Okay, so it says you'll pay today. Let's
Where
see
do I
here.
need to pay at?
You can come up and pay in person, or you can log in to the court website and use your case number to make payment. If you pay today, I will waive the fees that have been attached. There's a $25 fee plus a $16 fee, and you can pay the original fine of $55, okay?
Yes, ma'am. Am I allowed to say anything else, ma'am?
You are, yes.
I do apologize for I guess missing the court date because on my paper it said it was Tuesday. I did come in that following day because I did think it was court. I did not have the money to do that class. I apologize for that as well. I did go to the place last week and they have me set up for Wednesday. I am a single father. My kids do have I have them in Bible quizzing, and they do have nationals coming up on the 18th in St. Louis, Missouri, or not St. Branson, Missouri. And that's from the 18th to the 24th. I'm the only one that do support them on that. I'm the single father. I am asking for a request. If I can't go, I do understand, but then that means they can't go.
You say you have them in Bible what?
Bible quizzing. It's where they're only 5 and 6. They quizzing in a national tournament that they won the districts in Michigan. Now they're on to nationals, which is in Branson, Missouri, where they quiz against other states.
We had that in my Catholic school.
Branson, Missouri does a lot. I went to Christian overnight camp in Branson, Missouri when I was a kid. There's the thing, Mr. Jenkins. Your attorney can't come in the court and say he didn't take care of what he should have taken care of in January because of finances, but then you keep requesting to travel.
And what I traveled for before was my mom's retirement party, which my mother.
No, I'm not asking you. I'm not asking you why you're traveling because that's traveling costs money, and it also takes time. And it also takes time. And what you needed to do was not a class; it was an assessment, which you could have gone to Crystal Ray, and there were resources available to help people who couldn't even afford to get the assessment. You could have gotten it done.
When I called and spoke with them, they told me it was $200. My previous attorney told me that it was $200, and I couldn't do it. I didn't have it.
In 6 months, you didn't have $200.
I did not have $200. I lost my job because of this. I drive for CATA, and now. Okay,
if you could find people to finance your travel, then you could have found people to help you take care of the court order, or you could have let your attorney know, I can't do it. The court can have somebody.
I thought you was done. I'm listening. Go ahead.
Oh, okay, no, our probation does assessments for cheaper than $200. I could have had you assessed by a probation officer.
I didn't get to speak to my attorney till last week. She has reached out to me twice before that, but we didn't get to speak for the first time until last week. I had got a new attorney. So that information that I got from the previous attorney, I asked her, who I have now, I asked her, I said, I don't have the money. And she said the cheapest place was $200. That was what my last attorney officer told me. So I'm like, I can't afford it. I'm just going to plead not guilty and fight it. That was my plan. Then after I talked with my attorney last week, I immediately went in and figured out that I can get help with it, and went in and spoke with Crystal Ray, ma'am.
You're telling me, I'm hearing all the things that you're saying. If you knew how many drunk driving cases we deal with weekly, it is very rare that, and we have people that come through here with far less means than you have. It's very rare that I have somebody with a public defender, which means that they're considered indigent, who's traveling as much as you. That's number one. That's rare. That's rare. No, this is not a back and forth right now. That's rare. The other thing is, it's very rare that I have a drunk driving that it takes 7 months to get an assessment.
Mm-hmm.
If it takes 7 months, it's because you refuse to do it.
Okay. Am I allowed to speak, Your Honor?
No, I think I've heard what I don't want to hear any more excuses. I want it done. If you're not going to do it, then we have to move forward with the trial.
Yeah, that's fine.
I can't just keep setting it out. It's not about whatever I want to. I've been more than gracious. I've given you 7 months to get it done.
Okay. I mean, there's nothing you want to hear from me, Your Honor. I'll do what you say, and we can move forward.
Okay. We'll see you in person July 20th, 8:15 for a final pretrial. If there is no resolution that date, the matter will go to trial on August 3rd, that is. And then I'll note that you'll make payment of $55 on the expired meter today. And if you do that today, the court will waive the balance. Any additional matters for the record?
No, Your Honor, thank you.
Not from defense, thank you.
You're all set today, Mr. Jenkins.
All right, let's go on the record. Everybody at ease for a minute. Today is the 30th of June. It's Tuesday afternoon, which is the time we do preliminary examinations. We knew as early as last Tuesday, we had more scheduled for this afternoon than we had the ability to do. The very first case we're going to take up is People versus Jamie Lee Schrock. Mr. Schrock is here, and his counsel is here, and special prosecutor is here, and we'll be dealing with that one in a minute. We're trying to figure out what else we've got that we need. Also concerned are the bailiffs who have to go bring over any in custody defendants. I met with the bailiff staff first thing this morning and said, don't do anything until you hear from the court. Also, that little makeshift holding cell back there is about 110 degrees. So we're going to start with Schrock. Let's see where we go from there. Mr. Bradshaw Chapa is on bond. Mr. Bush, what are we going to do with that one?
The county exam.
All right, that's still stuff for prelim. Naomi Morris and Whitney Haroon. One is Mr. Truckees and one is Mr. Bush. Those defendants are on bond. Apparently, neither one of them have appeared.
They're here. I mean, my
they're here?
client's in the hall.
Oh, they're here. Okay.
Your Honor, those cases were adjourned so that they could discuss matters with the sheriff's department. Mr. Bush's client has, but Mr. Truckees was unable to meet because Deputy Van Dyken had was unable to do it, so that's being rescheduled. I'm pretty sure this room will be resolved, but I'm asking the court to grant another 2 weeks.
All right, so we bumped these both back 2 weeks.
Included in the stipulation I submitted was a vacation from the 15th to the 22nd. So
So after the 22nd.
yeah, after
And the chances are.
Just a minute.
Probably.
So Whitney Len Maroon, she is here. We're agreeing to adjourn that matter for 2 weeks till at least July 22nd, PEC. And Naomi Morris, that's Mr. Truckey's client. We're going to adjourn that until no sooner than July 22nd.
So you said July, that's a Wednesday. Did you mean July
I
21st?
did mean July 21st. Ross gave me the bogus date. So you'll be on vacation till the 22nd? All right, so that takes us back one further week, which will be July 28th. Somewhere are there some stipulations to adjourn floating around?
Yes, I submitted one that was signed by Ms. Davis this morning.
I mean, it hasn't made it to me yet. So those matters are both adjourned. There's gonna be two less we need to deal with. Robert Curtis has two files. That's Mr. Bush's case. He is on bond. Mr. Bush, what's the status? of
I'm
that?
sorry, Judge, who are we talking about?
Robert Lawrence Curtis.
That's gonna be examined. He wasn't here last I checked, but maybe.
Let's see where he comes. All right, this defendant is in custody, Jermaine Hadley. He's been in custody for 23 days, and if we need him, we're gonna have to go get him. Do we know what we're doing with him?
I believe that'll be examined.
All right, James Roberts.
I believe that's an exam too. He's in custody.
I was told all the witnesses have been discharged, so do you have any knowledge of that one, Gary?
Yeah, I'm gonna have to get the same Canfield up here because.
I think there is one case when they have a witness. It's
Matthew Kasdorf is Mr. Mitchell's case. He's been in custody for 30 days. Mr. Mitchell, what do you know about your case?
I just wanted to speak with Gary real quick before we discuss that one.
Will we need to have him zoom in?
I'll just drive to the jailer for waiver,
All right, so we expect a waiver in that case.
most likely.
All right, Ross, it appears we're going to need James Roberts, Jermaine Hadley, and I guess that's it. We may have to do them one at a time. I don't want to have you bring both of those when somebody sit in there and parboil while we do our other stuff. All right, in the meantime, the parties are going to continue to discuss their cases. Don't get anybody yet. And, but everybody, I think, is ready to go on Schrock.
Yes, Your Honor.
All right, Mr. Schrock, been here like 9 times in a row. We are not going to be able to finish all these prelims in the allotted time. We're going to focus, I guess, on the in custody ones. All right, let's stop the record and restart it. And it's only about 84 in here, so that's good.
She already paid me. Great, thank you. You know what I mean. Hi, Jake.
All right, let's get to work. First matter we're going to address today for preliminary examination is People versus Jamie Lee Schrock. That's you, sir?
Yes, sir.
And you're here with your attorney, Casey Strong.
Yes.
Also present is our special prosecuting attorney from Kalamazoo County. You've introduced yourself. Why don't you go ahead and place your appearance on the record?
Thank you, Your Honor. Holly Thompson on behalf of the people with the prosecutor's office in Kalamazoo County.
Mr. Schrock, you are charged in a formal complaint that alleges in this case 26502FY that you assaulted Amanda Binkley, an individual who you had a child in common and a dating relationship, by strangulation or suffocation. That is a felony. It's punishable by up to 10 years imprisonment. Count 2 alleges domestic violence, third or subsequent offense. Same date, same place, same complainant. Felony punishable by up to 5 years imprisonment and a fine of up to $5,000. You're also charged as third habitual offender, which would theoretically make the great bodily harm charge punishable by life imprisonment. There was a plea offer that was discussed earlier. The defendant has been steadfast in his request for a preliminary examination in this matter. Are we ready to proceed?
We are, Your Honor.
Okay. Let me give you a caution. We have a dysfunctional microphone, so we stole the one from there to there. So if you're at the podium, would you take your little disc mic with you? And that would be helpful. Are the people ready to proceed?
We are, Your Honor. Thank you.
All right. You wish to make any opening statement or just call your first witness?
We are ready to call our first witness.
All right, you may call your witness.
The people call Amanda Binkley.
This courtroom is a little different, so there's a kind of a twist and turn. But when you get here, will you stop, face me and raise your right hand? You swear or affirm any testimony you're about to give of this matter will be true to the best of your knowledge and belief. Have a seat if you would. Is the green light on that microphone?
Yes.
All right. Would you state your name for the record? You spell your first and last name?
Amanda Binkley, Amanda Binkley.
Ms. Thompson?
Thank you, Your Honor. Miss Binkley, I just want to let you know it's a little bit echoey in here, so if you can make sure to speak into the mic and project your voice. I know it's hard to remember sometimes. Okay. So first I want to start by asking, do you know someone by the name of Jamie Schrock?
Yes, I do.
Okay. How do you know him?
He's the father of my 3 kids.
Okay. And what are those kids' names?
Ava, Jaden, and Jake Schrock.
Okay. And how old are they?
16, 15, and 14.
Okay. So is Jaden, who's
Ava is the oldest, and then Jaden and Jake.
Okay. Now, were you residing with him earlier this year in March of this year, 2026?
Yes.
Okay. And do you see him in the courtroom today?
Yes.
Okay. Could you please identify him by an article of clothing he's wearing?
Black shirt.
Okay. Let the record reflect that the witness has identified the defendant.
She did point at him and he is wearing a black shirt. So yes, witness identification will be reflected in the record.
Thank you, Your Honor. Okay, so where were you residing with the defendant in March of 2026?
At his house in Sturgis.
Okay, in Sturgis. Is that in St. Joseph County?
Yes.
Okay. Now, you said you were residing with him. Were you in a relationship with him?
No.
Okay. When you had his children, were you in a relationship with him?
Yes.
Okay. And about when did you end the romantic relationship?
After 14 years in January of 2020.
Okay. And who else were you residing with when you were living with him in March of this year?
It was just him, our 3 kids, and then his girlfriend, Shanda.
Okay. And how had that been going?
Great.
Okay. Were you making payments on because you were living with them?
Yeah, I had given him money.
Okay. And did you have belongings there?
Yes.
Okay.
All right, let me make sure I got this. Whose house is this?
James.
And you were staying at James?
Yep.
All right, what's Shannon's last name?
Archer.
All right. So he was living there. What was the children's primary residence?
There.
All right, so he, his girlfriend and children were living there and you were staying there and paying rent.
Right, correct.
And how long had you been there?
A month and 2 weeks at the time of the incident.
All right, go ahead.
Thank you, Your Honor. Okay. Now, do you remember the police responding to that residence in March, on March 17th of 2026?
Yes.
Okay. And without fully going into details yet, do you remember what led up to that?
Yes.
Okay. All right. So first I want to ask, when did the incident leading up to the police responding begin? About what time that day?
It was later in the evening.
Okay.
I don't know exactly what time.
Was it dark outside or light outside?
Yeah, dark.
Okay. And what were you doing?
Actually, I was playing Fortnite.
Okay, is Fortnite a video game?
Yes.
Okay. And where was that?
In his bedroom.
Okay. Had you done that before?
Yeah.
Okay. Did you have any issues with them, with the defendant or his girlfriend?
No.
Related to that?
No.
Okay. Okay, at some point, did the defendant come in the room?
Yes.
Okay. And then can you tell us what happened after he came into the room?
He walked into the room and grabbed me by my throat and put me back on the bed.
Okay. So let's break this down a little bit. When he came into the room, what was his demeanor like?
He was yelling.
He was yelling. How loud?
I mean, pretty loud.
Okay.
Enough to get the whole house's attention anyway.
Okay. How close did he get to you while he was yelling?
Right here.
Okay,
in
let the
front of my
record
face.
reflect the witness was holding her hands about, can you turn sideways?
6 inches from my face, probably.
Okay. Okay. Okay, and then you said he grabbed your neck. Can you describe what the grip felt like to you?
It just shocked me, and I didn't really have time to react. I mean, the boys were right there as soon as he grabbed me, pretty much.
Okay. When he grabbed you, were you able to breathe?
No.
Okay. Were you able to get him off?
No.
Okay. And when you say the boys were right there, who are you talking about?
My sons, both of my sons.
Okay. And so they were, can you remind me, at the time they were
13 and 15.
13 and 15. Okay. And just to make sure I'm right, so Jaden was 15 and Jake was 13?
Yes.
At the time? Okay. Okay, so were you able to see what was going on as well, when you say the boys were right there, what do you mean?
So as soon as I remember being put back on the bed, they had grabbed a hold of him and pulled him off of me.
Okay. And was that a struggle or did he just let go?
Struggle.
Okay. And during that struggle, did you observe either of the kids sustain any injuries?
Yes.
Okay. Which kid or both kids?
Jaden.
Okay. What did you observe?
So at the time of the incident, I didn't see him getting any injuries, but as soon as it was over with, he had scratches and stuff on him.
Okay.
From the incident of him trying to pull him off me.
Okay. And to your knowledge, was the defendant aware that the children were home?
Yes.
Okay. Was Ava present in the home as well?
Yes.
Okay.
Let me stop you for a minute. You may be going here, but I'm interested in this. You're in his bedroom? Is that yes?
Yes.
All right. And you're sitting on the bed playing
Yes.
this game?
Yes.
Are the boys also playing?
No, the boys are laying in their bed.
All right,
In
there's
their
more
own
than-
room.
There's more. All right. So the boys were not in the room with you.
Right. Correct.
All right. You were in Mr. Schrock's bedroom on his bed.
Yep.
Were you sitting in the bed or laying in it?
I was sitting in the bed and his girlfriend was sitting on the other side of the bed next to me. And we were both watching the TV.
Was she playing the game also?
She was watching me play the game.
Okay. Helps me understand.
Thank you, Your Honor. Okay, so you said the children were in bed. So were they in bed when this incident occurred, when the defendant entered the room?
Yes.
Okay, do you know about when they came in the room themselves?
As soon as they heard him yelling, they got up out of their bed.
Okay. And you described how you felt physically. How did you feel emotionally during this moment?
Nervous, scared for the kids, for myself.
Okay. Now, did you call 911 right away?
No.
Okay. Can you describe kind of what was going through your head in deciding not to?
I just wanted things to calm down and the boys to just for it to be over with. So I didn't call because I didn't want to have police or have the kids see anything with the police and their dad being arrested or anything like that.
Okay. Did you eventually call 911?
Yeah.
Okay. And what happened with that? What prompted you to call 911?
So that would have been later after Becky showed up,
Okay. Who's Becky?
my cousin.
Okay. Do you know what Becky's relationship with the defendant is?
I do not.
Okay.
You said she's your cousin?
Yes.
Your cousin or his cousin?
My cousin.
All right.
Okay. And is her last
What's
name?
Becky on it?
Binkley.
Say it again?
You said, what's her last name?
Yes,
Binkley.
Binkley, okay.
Okay. When she showed up, where was the defendant?
When she showed up, he was walking her into the house with
Okay.
her, so he was with her.
Okay. And what happened?
She started swinging on me.
Okay. Did you say anything to her before that?
I don't believe so.
Okay. Did she say anything to you?
Yeah, she was telling me it was time to go.
Okay. Did she or the defendant offer you any explanation?
No.
Okay. Now, I'm sorry, I should have addressed this earlier, but I want to go back to this. You described seeing injuries on Jaden. Can you indicate where?
On his neck area, chest area.
Okay. What did they look like?
Scratches.
Okay. Did he have those earlier that day?
No.
Okay. Now, did you sustain any injuries?
Yes.
Okay. Where?
On my neck.
Okay. Can you describe what that felt like?
It was scratch marks and red.
Okay. Anywhere else?
I don't believe so.
Okay. Do you remember anything with your lips?
No.
Okay. Do you remember seeing, or do you remember getting photos taken of you that night?
Yes.
Okay. And do you remember looking in the mirror later that night?
Yes.
Okay. Would you be able to recognize those photos if you saw them?
Yes.
Your Honor, I don't believe that she can authenticate photos that she did not take. She's already answered that she doesn't recall any injuries to her lips.
Well, she can look at them and see if she recognizes herself and if they're fair and accurate pictures of what she looked like. So let's lay a foundation and see where we go.
Yes, Your Honor. I was about to ask if they would they refresh your recollection of that night? Okay, Your Honor, may I approach?
Before we get there, I'm interested in the time frame. You didn't call the police. I'm not sure what time it is. It's dark. It's late enough that these teenage boys are already in bed.
They were not asleep yet.
All right,
yet,
so
though.
what time was it? Like,
Probably around 9-ish, I'm guessing.
all right, how much longer before Becky Binkley showed up?
An hour, probably.
So it's now about 10 o'clock? And it was after that you called 911?
Yes.
You said she swung on you. Did she hit you?
She tried to, yeah, a couple of times.
But did she actually hit you?
Yes.
Where?
My face.
All right, so these pictures were taken after you got also hit by Becky?
Yes.
All right, you may show her the exhibits.
Your Honor, the defense counsel has been provided a copy of these photos, which I'm approaching the witness. Ma'am, do you recognize those photos?
Yes.
Okay. Well, you can continue to take a look at them. Who is that in those photos?
Me.
Okay. And what are you wearing?
A hoodie.
Okay, is that the hoodie you were wearing is that what you were wearing that night?
Yes.
Okay. And do you recognize, does that refresh your recollection?
Yes.
Okay. Do you remember sustaining other injuries aside from injuries to your neck?
No.
Okay.
But well, just my face.
Your
The
face?
lip area. Yes.
Okay. Okay. And I just wanted to ask you, so the officers arrived that around the time that who you call Becky, your cousin, showed up. That's right.
So after she hit me a couple times, I went into the bathroom.
Okay.
And shut and locked the door.
Okay.
And Shanda was in there, and I had told her that because at that time when I shut and locked the door, Jamie and Shanda were both trying to kick the door down. And I can remember saying that if the door gets kicked down, I knew I would black out at that point.
Okay. Why is that?
Because I was trying not to participate in the fight necessarily. So I was trying to go into the bathroom and stay in there.
Okay.
But I knew that if the door came down, I was fighting.
Okay. Okay. And as you stated, those photos are accurate to what an accurate depiction of what you looked like that night.
Yes.
Okay. Your Honor, at this time, the people would move to mark and admit People's Exhibits 1 through 3.
No objection, Your Honor.
All right, they be admitted.
May I approach?
Yes.
Ma'am, did you experience any
Just a minute.
sort? I'm sorry.
These are pictures primarily of your face and lip. Is there also a bump on your chin, or is that just
Possibly, yeah.
all right? So who hit you in the lip?
Becky.
All right. So these are photos of injuries you got from Becky.
Yes.
Not question relevance here, but do they show any injury on your neck?
Those pictures?
Yes.
No.
Did you take other pictures of your neck later?
I don't remember.
Okay.
I might have. If I did, they would still be in my phone.
Okay. Okay. How did your neck feel?
Sore, I guess.
Okay. Now I'm going to ask you, was this the first time the defendant grabbed your neck?
No.
Okay. When had he previously grabbed your neck?
Back when we were in a relationship together.
Okay. Do you know about when?
There's been more than one time.
Okay. Can you give estimations of those dates?
So I know there was one around the time Jaden was 5 or 6 years old. Another maybe around 2019.
Okay.
Right before we ended up splitting up.
Okay. And during those instances, how did he grab your neck?
With his hands.
Okay, both hands?
Yeah.
Okay. In those instances, were you able to breathe?
No.
Okay. How did those end?
The one ended when our son walked in the room. And he thought that he was pulling my hair. So he asked his dad, why are you pulling my mom's hair? And as soon as he said that, he let go.
Okay. And then what about the other? Was that the earlier one?
Yeah.
The one from 10 years ago?
Mm-hmm.
Okay. And what about the more recent one?
The recent one would have been right before we split up and separated in 2020.
Okay. Now, when those occurred, were you also in St. Joe County?
Yes.
Okay. Did you contact the police during those instances? No. Why not?
I didn't want to get him in trouble.
Okay. Were there other instances in the last 10 years where you felt assaulted by the defendant? Or threatened?
Yeah.
Okay. Can you give an example?
Just when he gets angry and yells.
Okay. And why does that make you feel threatened?
Because I just never know what to do.
Okay. And what does that look like when he's yelling? Can you describe it?
So when he's yelling, what does it look like?
Yes.
Usually he's in my face yelling. I don't know.
Okay.
What you mean by that? Like, what does it look like?
Well, what's his stance like? How close is he to you?
Usually he's pretty close and arms are waving around and he'll be yelling and
Okay. Is he taller than you? I'm sorry, the door just closed. Can you say that again?
Yes, he is.
Okay. I just have one other question for you. So you said that Becky told you that you needed to leave the house. Did she live there?
No.
Okay. Had defendant or his girlfriend ever spoken to you about you moving out or wanting you to move out?
No.
I have no further questions, Your Honor.
Ms. Strong? This is Attorney Casey Strong. She represents the defendant. She has an opportunity to question you. This is called cross-examination. You are still under oath.
Good afternoon, Ms. Binkley. So you were in a relationship with the defendant for 14 years, correct?
Correct.
And you said it ended about January 2020?
Correct.
And how did it end?
I ended up kicking him out of the house.
You kicked him out of the house? And is that the house that he's in currently that you were residing with him, or a different house?
It's a different house that we resided in together.
Okay. And did you sell that house?
No, we were renting.
Okay. And at what point after breaking up in 2020 did you move back in with the defendant and his girlfriend?
It was just a month and 2 weeks prior to the incident.
Okay. So March.
Yeah.
Was it in March?
So I broke my leg at work on February 2nd and was off on work comp. So I'd been getting calls from the school with over truancy and them not making it to school. So my intention was to go stay there in order to make sure that the kids were getting to school like they were supposed to be.
And where were you living before you broke your leg?
I was living with my dad.
Okay. And you said that you were paying rent.
I had paid him money for rent, yes.
Okay. Was that consistent or inconsistent?
I mean, I was only there a month, so
Okay.
I gave him over 1,000.
And that night, when the night of the incident, why was he yelling? What was he angry about?
He was angry because I had texted my daughter's friend and had said to her, asking her what I could get my daughter for Easter, ideas of gifts and things, because her and I relationship is kind of rocky. And I had said something to the effect of, it doesn't matter what I do, it's not good enough. And her dad can steal, lie, and he's still untouchable to her, basically. And so she must have said something to him about that text, and that's what he was mad about. When he came in the room, he said I was talking shit about him.
Okay. And so that's why his voice was raised in the first place. He was talking, you were talking, he perceived you to be talking explicitly about him.
Right.
And he was not asking you to move out?
No.
He didn't ask you to move out that night?
No.
No one would have heard that or thought that?
I don't believe so, no.
No. And you didn't call 911 right away?
No.
So you testified that the incident happened around 9-ish in the evening?
9-ish, yeah, it was dark.
Okay.
And the kids had laid down for bed, so yeah.
And Becky arrived around 10?
Yeah, about an hour after the incident.
Okay, and about what time were the police called?
As soon as the fight between her and I was over.
Okay, so you called them right after you finished?
Or during, actually, because I believe that it was the 911 call was already like dialed and called when we were getting into it in the bathroom.
Okay, so who called 911?
I believe I did.
You believe you did?
I can't remember. I don't know if it was me or one of the kids.
Okay. And when you were in the bedroom, you were in his bedroom, correct?
Correct.
You were on his bed.
Correct.
Was the door open or closed?
Open.
And about how far from his bedroom are the boys' bedrooms?
Right next door.
And how many bedrooms are in the home?
3.
So his bedroom, the boys' bedroom, who was in the third bedroom?
Ava.
And where were you sleeping?
Couch.
And is that in the living room?
Yes.
Is it all one floor?
Yes.
Okay. And you said that the boys were not initially in the room with you when he came in yelling.
Correct.
Who was in the room when he came in yelling?
His girlfriend.
Was that the only person?
Yes.
About how long from him yelling to when the boys came in the room?
Maybe 15, 20 seconds.
Okay, 15, 20 seconds. And from the time that the boys came in the room, how long was it before he allegedly grabbed you by the neck?
He had already grabbed me by the neck when the boys came in the room.
Okay, so tell me again, the yelling started, and then how long into the yelling did he grab you by the neck?
Like, so when he walked into the room and was yelling, he was already making his way to me.
Okay, so he immediately came up to you and
Yes.
grabbed you by the neck.
Yes.
Okay, in front of his girlfriend.
Yes.
And then the boys came in.
Yes.
Did Ava come in at any point?
I think so.
And you testified that there was a scuffle and the boys pulled him off.
Correct.
Was anybody else involved in that scuffle besides you and the boys?
No.
And were the boys involved together or separately?
Together.
Okay. And were there hands and arms and elbows being thrown around across the board?
Besides the defendant, no.
Okay. And you said that Becky came around 10 p.m., about an hour later?
Yeah, probably about an hour later because everything had calmed down at that point.
Okay, so everything was calm when she got there.
Right.
Why did she come over?
Because the defendant called her.
Defendant called your cousin?
Yes.
Okay.
Objections, speculation.
I believe she testified to this on direct examination, why Becky was called to the house and who called her.
Well, Becky came. How do you know that he called Becky?
I believe Shanda told me that, and then
That's hearsay. So, I
he
guess
is, I don't know. He walked her into the house, so
you didn't hear him make the call,
no.
but he went out and greeted her and walked in with her.
Yep.
All right.
And you said that you and Becky got into it. You got into a physical altercation?
Yes.
And the photos by law enforcement that you admitted, those were taken after your fight with Becky.
Correct.
And what injuries did you receive from Becky versus injuries from the prior incident?
I don't know. It all happened so fast. I'm not sure which ones were caused by her, which ones were caused by him.
Okay. And you said she hit you a couple of times.
Correct.
How many is a couple?
2, 3.
2. And did you fight back?
At first, no.
And did you fight back at any point?
Yep.
Did she sustain injuries as well?
Probably.
Had you been drinking that night?
No.
Not at all?
None.
Sure?
Yes.
And did you tell law enforcement about the fight with Becky?
Yes.
Okay. And you testified to the defendant grabbing you by the neck previously about 2 times.
Correct.
One when Jaden was about 5 or 6 years old.
Correct.
And one in 2019.
Correct.
Were any of these voluntary or part of your domestic relationship?
What do you mean?
Were they part of a domestic intercourse relationship?
I don't understand.
How do I ask this a different way? During your intercourse with the defendant, was that part of your relationship? Hair pulling, choking, things like that?
No, not
Not at all?
regularly. Not regularly, no.
Okay. Your Honor, I have no further questions for this witness.
Ms. Thompson.
Just briefly, Your Honor. Now, when you went into the bathroom, is that around the time 911 was called?
Yes.
Okay. And were both defendant and Becky at the bathroom door?
Correct.
Okay.
The kids had already tried to pull her away off of me, like in the living room when we first got into our initial encounter. And the defendant was trying to pull the kids off of her and saying this needs to happen.
Okay. Okay. Then I also want to ask, in any of the 3 instances, either the instance at issue today, where your neck was grabbed by the defendant, or those other 2 instances you described, were any of those consensual, the hands on the neck?
No.
Okay. How do you feel emotionally in those other two instances?
Sad.
Okay. Were you concerned for your safety?
Yeah.
Okay. I have no further questions.
That only raises one for me, Your Honor. You said when you were out in the living room, someone kept saying this needs to happen. What needs to happen?
He was wanting her to fight me. The kids were trying to pull her off and crying and trying to stop the fight. And he was pulling the kids away, saying, basically, let it happen because it needs to happen.
No further questions.
All right, I was gonna ask that. So your assumption was that Becky was come over to be the enforcer and beat your butt?
Correct.
What's your relationship with her?
We don't speak.
You indicated you had not been drinking. Had he been drinking?
No, nobody had.
No drug, how about marijuana or any other drugs?
Nope.
And he was angry about things you had texted to someone else.
Correct.
And you presume that person then texted him and say, this is the stuff your ex-wife is saying about you?
No, I believe it was my daughter's friend. So I think that she had said something to my daughter and my daughter had said something to him.
All right, how close in time frame was that?
So I had texted her the day before.
Okay, from the day before. So you're sitting there on the bed playing video games and he comes in hot right off the bat.
Correct.
And when did you learn what it was he was mad about?
Pretty much as soon as he came into the room, he said, you're talking shit about me. And I said, what are you talking about? And he said, you're telling Ava and her friends that I'm a thief. And I proceeded with, it's not a secret that you're a thief.
All right. Does that raise questions for anyone else?
No, Your Honor.
Just one question, Your Honor. Did the defendant have reason to know that you and Becky were not on speaking terms?
Yes.
Nothing further.
Thank you. You may step down. Ms. Thompson?
The people rest, Your Honor.
We have no witnesses for purposes of the preliminary examination.
All right, argument and motions?
Thank you, Your Honor. The people would ask that the court bind over on both counts and include an added or amended count of child abuse third degree. As for count 1, strangulation, the defendant, I think we had substantial evidence through testimony of the defendant's intent to grab her neck, to in some way impede her breathing. We know that he was angry. We also know that there were prior incidents where he had grabbed her neck before. We know that when he grabbed her neck, she was not able to breathe. She was not able to get him off. This would also be a battery, and they're in a domestic relationship. So that would meet the elements of domestic violence. I think that people could proceed onto alternate theories of domestic violence, both on the strangulation and a sort of aiding and abetting theory with what happened with Becky. I think that the photos, while unclear when those injuries were sustained, do corroborate the victim's testimony. And I do believe an added count of child abuse third is appropriate because this was an intentional act by the defendant when he approached his ex-wife or his ex-partner and begins to strangle her while he knows children are in the home, screaming loudly. They get up, they try and remove him from their mother. She testifies that he did not just let go as soon as he realized his children were in the room. Instead, he struggles. And then Jaden sustains injuries that she's able to observe. This is an intentional act that was likely to cause injury, physical injury to a child, and physical harm or physical injury resulted. The statute doesn't require serious injury. It just requires that the defendant's intentional or knowing act was likely to cause physical injury and physical injury resulted. I would ask that the court bind over on the 2 counts, as well as the amended added count of child abuse third. I also want to place on the record that the people are noticing under 76827B other acts, and that this will serve as disclosure to defense counsel of other acts of domestic violence. Thank you, Your Honor.
Ms. Strong?
Thank you, Your Honor. We heard testimony today from the victim in this matter regarding 2 fights during the date of the incident. One where she alleges an incident with the defendant, and one where she details a fight with her cousin, Rebecca. And the law enforcement call was not placed after the interaction with the defendant. It was placed after a fight that she disclosed with Rebecca, and photos were taken after that time. She was unclear about what injuries she sustained during each fight. She could not delineate. It seems like from her testimony, there were numerous altercations, and we have no way of knowing what the altercations stemmed from or what the injuries stemmed from. As to the child abuse third, there was testimony that there were scratches observed on Jaden, but she only testified that she did not observe them previous in the day. We have no information about how they were received. There were multiple people involved in this altercation and the subsequent altercation. We do not know that it was the defendant who caused those scratch marks. Further, there was no testimony presented about prior convictions for domestic violence by Mr. Schrock. So I would ask the court not find this over.
Those are attached by operational law. They used to, in the old days, you guys weren't born yet, you had to prove every prior offense. And you had to either bring in a probation officer. Once I brought in an FBI agent from Washington, D.C. to fingerprint a guy in the courtroom and prove that he was the same guy that was convicted previously. It's much less onerous than it was then. All right, this is just a small snippet of this incident. Ms. Thompson, do you have any last argument?
Your Honor, I would just note that this is a probable cause hearing. Clearly, we would have certainly more evidence, more witnesses at trial, but I believe we have established the elements for these counts, but also for the added count of child abuse third. Thank you.
And I appreciate that. We don't need to hear from every witness at a probable cause hearing. Mr. Schrock, this is a probable cause hearing for everybody else. You don't get found guilty or not guilty at a preliminary examination. They just have to establish probable cause that a crime was committed and probable cause that you did it. That's a pretty low standard. Well, clearly it was you, and probable cause that a crime was committed. The witness testified directly. You came in hot, angry, and grabbed her by the throat and pushed her back on the bed, and she felt like she was being strangled. She testified there are special statutes in domestic violence cases which allow the prosecutor to bring up previous incidents. This is only a preliminary examination, not a jury, but there'll be probably some argument about allowing these other acts in if we get to trial. But for this purpose, I can consider it. So there certainly is a probable cause that you did it and that you choked her, which supports count 1. That also supports a count of domestic violence. And the record reflects that you have 2 previous convictions for domestic violence, which makes that a 5-year felony. Probable cause and proof beyond a reasonable doubt are 2 different things. There's a bunch of people we didn't hear from. We didn't hear from your girlfriend. We didn't hear from the boys. Hear from police. Didn't hear from Becky. There's a lot more to the story than the snapshot I have of it. Child abuse 3rd degree is a stretch. I love it when they throw in a count at the last minute. But sometimes you don't know it until you take the testimony. But I think it is a stretch. Child abuse 3rd degree, the elements are the defendant is charged with 3rd degree child abuse. To establish this charge, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant is the parent. The only child that apparently had an injury was Jaden, and there's no dispute that you're Jaden's father. Second, the defendant had care or custody or authority over the child. you and the child's mother were not married, but the child was living in your house and you had care and custody over it. Second, the defendant either knowingly or intentionally caused physical harm to the child. I don't think that element is there. I don't think you knowingly or intentionally caused physical harm to the child. Second, this is a little more open-ended. The defendant knowingly or intentionally committed an act that was, under the circumstances, posed an unreasonable risk of harm or injury to the child, and that the act resulted in physical harm. Knowingly or intentionally committed an act that posed an unreasonable risk of harm to Jaden Schrock. He wasn't in the room. She's on the bed playing a video game. He's in his own bed in another room, and so's Jacob, so's Ava. So you come in, you're angry about things that she had posted or shared about you, and put your hands on her. I don't know that intentionally or knowingly posed an unreasonable risk of harm to your son. Now, there might be an assault and battery or even a domestic assault for putting your hands on him where he was injured. And finally, the child was under the age of 18. This young man was. So there may be something else, but I don't think it's a felony offense of child abuse in the 3rd degree. So I declined to bind on that count. So I do have a bind over. I'm going to sign it. Bound over to appear at a status conference, which will be months and months from now. Right now, we're at a position where we don't have a circuit judge and we're relying on visiting judges. Probably will be for the remainder of the year. The next step is to set a status conference, and that'll be some time from now. My guess is this case isn't going to settle. Bond was set in the amount of $10,000 cash or surety that you have posted. There are conditions of the bond: no assaultive or threatening behavior, no contact with Amanda Binkley. I didn't ask what happened, but presumably after the night you went to jail, were you given a no contact provision? Or were you able to go back to your house when you got out of jail?
Since there was no contact, I didn't go back to my house because she was there. I had to have state police remove her from my house.
Which you can't really do. She was a tenant, but at any rate, you're no longer living in the same house.
No,
That's correct,
I'm
Your
back.
Honor. They're
What's
no
that?
longer living in the same house.
All right. So, and it shouldn't be a problem for a no contact. As a practical matter, the state police probably can't just kick her out. She was a tenant. You would have had to go through an eviction process, but they short circuited that. All right. This matter is out of my hands. It will be going to the circuit court for further proceedings. So we'll stop the record, stop the live stream, see where we are.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Let me stop the live stream.
Let's go with the city of Detroit versus Cartavion Green. The case numbers and the state of Michigan versus Cartavion Green. Case number SP 187-91281, SX 4680145, counts 1 and counts 2. SP 1905876, counts 1, 2, and 3, and SX 4680153. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Green. Yes, Cartavion Green.
Mr. Green, I was talking about you the other day. You should took me up on that offer to get into the Wayne County Sheriff, because all you're doing is just sitting there racking up more and more tickets. And I don't know what you're doing with your life as far as working is concerned, but you certainly I've seen you almost since the first time since I got on the bench. And I don't know. Today's date and time is set for a trial date. Mr. Barry, I have officers Trooper Hardaway appeared and Officer Finley appeared. I don't see Officer Monfort. I didn't see an Officer Monfort. Mr. Green, I'm going to put you in the breakout room with Mr. Barry. He's going to attempt to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Mr. Green, are you working?
Yes.
All right, join the room, sir. Pass the matter. Let's go back on the record, Mr. Cartavion Green. Mr. Green, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client seeks a trial.
All right, let's call Ms. Horn. Tell her to get her officers back in here, please. We'll pass the matter. Today is the date and time set for the trial, right?
Yes, Your Honor.
All right, very well. Call Ms. Horn. Tell her to get her officers back in here. Are we ready on Cartavion Green? I'm sorry.
We're ready, Your Honor. Pay the defense.
Ready, Your Honor.
All right. Let's go recall on the record the city of Detroit and the state of Michigan versus Cartavion Green. Ms. Horn, can you put your appearance on the record, please?
Yes, Your Honor. Tamika Horn on behalf of the city of Detroit, P70303. Trooper Hardaway, would you please state your name and badge number for the record?
Trooper Christopher Hardaway, badge 1235.
And that's with the Michigan State Police, correct, Trooper?
That's correct.
And good morning to you. What about the other the other officer, Monfort? He didn't appear. So
that's correct, Your Honor.
You want to make a motion, Counselor? And what about Finley?
Finley, the people are moving to dismiss that and no insurance misdemeanor.
Right.
And I did consult with Officer Finley on that.
Very well.
As to Officer Munford, we would move to dismiss.
Mr. Barry.
We would move to dismiss for failure of a complaining witness to appear.
And has there been an? I'll grant the motion to dismiss. Has there been an offer on this? On these three cases here: careless driving, drive my license suspended, and unregistered untitled?
Yes, Your Honor. The offer to the careless driving was 6 to 10 miles per hour over speed. And as to the license issue, the people offered failure to display with a dismissal of the other remaining matters.
All right, you, Mr. Cartavion Green, you don't want to accept that offer? I'll fine you just a $240. I'll cut you a break on the 135 for the 6 to 10 over.
I don't, Your Honor. I did display insurance, registration, and I don't agree.
We're not talking about that now. We're not talking about that now. That's going to be what we're going to hear when we call the trial. So you don't want the offer, right?
No, sir.
Okay, let's go. It's time for trial. Ms. Horn.
Ready, Your Honor. And the people will call. It's first and I believe only witness at this time, Trooper Hardaway of the Michigan State Police.
Okay, Trooper Hardaway, good morning to you. Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, I do, Your Honor.
You can put your hand down.
And Trooper Hardaway, please state your name. You already stated your name and badge number for the record. Where are you currently employed?
The Michigan State Police Metro South Post.
And how long have you been a police law officer or in law enforcement?
11 years.
And please describe any training you've had, especially as it relates to traffic matters.
A host of training to include traffic crashes, speed measurements, traffic stops, and enforcing traffic laws.
And what did your training teach you to look for in regards to the charges that we are here for today, especially the careless driving?
Careless, negligent driving, driving that could lead to crashes.
And would that be crashes that are caused that may likely endanger other people on the road?
Absolutely.
Negligent in a manner that would likely be a danger to the respondent's own self?
Absolutely.
And as you stated before, operating in a way that may cause a traffic crash?
Correct.
Okay, thank you. On April 13th, 2026, at approximately 5:25 p.m. at East Davidson and Dean Street in the city of Detroit, were you on duty?
Yes.
Okay. And were you at that intersection at that date, time, and location?
Yes.
And what brought you to the area?
Just on routine traffic patrol.
And specifically, where was your location?
I was traveling westbound on East Davidson, approaching Dean.
Okay. And is Dean an intersection with a traffic control device or light device?
If not that intersection, there is one near it. I do believe it has a traffic control device there, though.
Okay. And what did you observe while you were at that location?
Well, while traveling westbound on East Davidson, approaching Dean, traffic was coming to a stop in observance of a red traffic control device. At that point, to my surprise, my radar began to read numbers over the speed limit, which caused me, my rear radar, which caused me to look in my rearview mirror. At that point, I noticed a blue-colored Durango going in and out of traffic. And what I mean by that is there was traffic coming to a stop. You could see this vehicle go from one lane to the other, and eventually.
And before you continue on, I just want to ask you, were you able to observe any signaling?
No.
Okay. And you said going in and out. I'll let you finish.
In and out of traffic is eventually occupying the right turn lane. As we proceeded to go past Dean, this vehicle went through Dean Street in that right turn lane.
And is that turn lane for turning only?
Correct.
Is it for passing, just to clarify?
No.
Okay. Continue, Trooper. Thank you.
This vehicle continued through the intersection, at which point passing my patrol vehicle, still occupying another lane reserved for turning only, at which point I initiated a traffic stop.
And when you initiated that traffic stop, what did you do?
I approached and made contact with the driver, who's identified as the defendant.
And do you see that person in the virtual courtroom today? The person that you stopped?
No. Let me see. I can't pull up their video right now. Yes, I do.
And can you describe something about that person?
Based off the video I see in front of me?
Yes.
It's a black male. He has a medium haircut, and he has looks like what believes to be a door behind him in the video.
Okay, thank you. If this is sufficient to the court, Your Honor, please note on the record that the trooper has identified the respondent in this matter.
Any objection, Mr. Berry?
None, Your Honor.
All right, I'll find that he's accurately identified the respondent and the defendant.
Thank you, Your Honor. And what did you do after you approached and began communicating with Mr. Green?
I was advised by Mr. Green that he did not have a license, a physical copy of his license or ID. He provided me with a jail form of ID.
Okay. And
what form of ID?
Yes, thank you.
His jail identification. He had mentioned he was incarcerated for a while, and he could only give me an ID that was issued by a lockup facility.
Sure.
Thank you, Your Honor. And what did you do then?
I took that information and I ran it through our systems to be able to identify him with a researched SOS photo of him through our system.
And for the record, what does SOS stand for?
Secretary of State.
And is there a particular name for the system that you use as law enforcement?
The Law Enforcement Information Network, otherwise we call it LEAN.
And is that something you use in the daily course of your business?
Yes.
And I believe the court has run a copy of Mr. Green's Secretary of State record, which I've reviewed. And that was printed by the court in its normal course of business. The people are introducing it as evidence.
Any objection?
No objection, Your Honor.
The people move for admission to evidence, Your Honor, with the Honor's permission.
All right, it'll be admitted.
And according to that lien document or the SOS that you ran, what did you discover, Trooper?
That Mr. Green was suspended.
Okay. And did you run anything else at that time
Yes.
that related to the vehicle?
Yes, routinely I ran the registration plate.
Okay. And what did you discover, Trooper?
That the registration plate was affixed to the vehicle improperly. The plate did not come back to any vehicle at the time.
And as to the 2017 blue Dodge Durango that you pulled over, what did you discover at all about its registration?
I went further to run the VIN that was affixed to this Dodge Durango and found that it was in the system as unregistered. It did not have any registration attached to it.
And what did you do after you made these discoveries during your investigation?
Mr. Green and all occupants of the vehicle was subsequently detained, and this vehicle was impounded as a result.
And did you issue any citations?
I did.
And what were those, Trooper?
Mr. Green was issued a driving while license suspended citation, unregistered vehicle citation, and a citation for his careless driving.
Thank you, Trooper. At this time, Your Honor, the people have no further questions.
All right, go ahead, Mr. Berry, you want to cross-examine?
No questions, Your Honor.
All right. All right, that'll conclude. Let me ask some questions. Mr. Trooper Hardaway, you indicated that where were you stationed when you first saw this blue Dodge Durango?
I was traveling westbound on East Davis Street, approaching Dean.
Westbound on East Davison, approaching Dean. And you indicated that on your testimony was that this vehicle was in your rearview mirror. Were you
Correct.
driving at the time?
I was coming to a stop, so yes, driving at the moment.
And how far away was this vehicle when you noticed it?
It was maybe a couple car lengths. It wasn't that far. Enough for me to see a full display of what the vehicle was.
Yes.
And what lane was this vehicle in when you first noticed it?
So there's two lanes that travel through there, and then there's that turning lane. Initially in that left lane, not in consideration of the center lane, center turning lane, but that left lane approaching, traveling westbound, approaching the cars that were behind me.
And what lane are you in?
I was in left lane as well.
So when you first saw the car was behind you?
Yes.
Now, when you say turning lane, are you talking about a left-hand turn there off Davison lane?
There is a right turn lane that reserved to turn right as you approach the intersection.
Of Davison and Dean?
Near Dean. There's two traffic lights. Now, there's one before Conant and then the Conant traffic light.
So we're talking about Ryan?
Ryan is there. So at or about Dean Street is the traffic stop was initiated at Dean Street. And I mentioned in the testimony earlier that there is a traffic control device that is at or near the intersection of Dean.
Right. The court can take judicial notice that there's a light at Ryan and Davison, and there's a light at Conant and Davison.
Right.
I don't know that is at Ryan and Davison, that curb lane is a right turn only lane though. But nevertheless, so the blue Dodge Durango would have been in the middle lane. There would have been a lane to your left and a lane to your right.
No. If he was in the left lane that is adjacent to a center turning lane, he was in the he got over into that right lane reserved for the right turn as you approach Dean Street.
Very good. Now, you indicated that you saw the vehicle going from left to right, switching lanes. Is that the only time they switch lanes?
From left to the right lane and then to the right reserve only turn lane.
So they're in the far left lane.
Yes.
Is when you saw, and you're in the far left lane, correct?
Yeah.
And they go from the middle lane to the turn lane, so they go over two lanes.
They go from the left, right, and then the turning lane, the right lane reserved for turning.
So they go over two lanes.
Yes.
Okay, and then what did you see next?
I began to, they traveled through the intersection and approach Conant. And that's when I initiated a traffic stop because they still occupied that right turning lane that was now reserved for Conant.
Okay. That the court has no further questions on that.
And just one question, Your Honor. Trooper, based on your description of the driving, was that passing on the right?
Yes.
All other traffic?
All other traffic on the right.
And that's once at that intersection of Ryan was crossed.
What do you mean?
Yeah, meaning that the lane you state was
Shut up.
reserved for turning. The lane that you stated was reserved for turning. This Durango continued beyond and did not turn to the next intersection.
Yes.
Okay, thank you, Your Honor.
And there were other vehicles in the other lanes, so you said you did see the vehicle pass the lane, pass the vehicles on the right?
Yes, it was. There were vehicles behind me occupying the lane I was in, the left lane, and then the right lane, and the Durango proceeded to go around those vehicles on the right.
All right. The court has no further questions.
The people rest, Your Honor.
All right. As far as the driving while license suspended, I have the driving record here that was admitted into evidence, and it indicates that at this time the driver's license is suspended, and this ticket was issued on April the 29th, 2026 at around 1:54 a.m. And Mr. Green, at least by this document here, states that on 1/28/2025, out of the 16th Circuit Court, Mr. Green lost his ability to drive a vehicle effective 12/25/2025 to 12/24/2026. So I'm going to find him guilty as to the driving while license suspended as charged. As for the vehicle being not registered, I have testimony that is been put in, it's been put on the record by the trooper and me saying that the vehicle was unregistered. There's been no other evidence, but yes.
My client has current his registration is operative at this time.
Yeah, very well.
The people would object to that being even considered based on the date of the incident.
Yeah, I wasn't going to find him guilty of that anyway. I did want to have more evidence of. I believe it could have been some documentation to show that there's not been valid registration at the time. Then I'm going to find him responsible for the careless driving.
Your Honor?
Yes.
Could we allow testimony from Mr. Green?
Is that what oh yeah, I'm sorry. I'm sorry. Let's do that. Let's do that. Before I will strike that. I will strike that guilty plea from the record because I did not allow Mr. Green to give his own testimony. So are we ready for that, Mr. Berry?
Yes, Your Honor.
All right, you raise your right hand, Mr. Green. Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Yeah.
All right, you can put your hand down. Go ahead, Mr. Berry, your witness.
Thank you, Your Honor. Mr. Green, you heard the testimony of the officer, did you not?
Yes, sir.
And on the date and time that he gave, were you driving the Durango vehicle?
Yes, sir.
And you heard the description of the manner in which you were driving?
Yes, sir. I heard him.
And do you have a different approach to that, or what would you have the court know about that?
Yes, I was on Davidson and Sunset, and that is a 3-lane street. Right before you reach Dean Street, it turns into 2 lanes. I was in the middle lane behind a semi truck, and I chose to get over to the right turning lane. And he flicked his lights, and I pulled immediately over. I was not all the way to the left lane. I did not get all the way from the left lane to the right lanes, meaning I did not go over 2 lanes. I was in the middle lane. I put on my blinker indicator to get to the right lane, and I got over to the right when it was safe to do so. The police, when he got his lights on, I was already in the right lane, and I just pulled over by the curb and pulled myself over. As far as him saying that I produced some type of jail card, I never had jail identification card. I only ever had my license on me, and I handed that man my license. I also handed him the registration and the insurance to that car at the time, which I have right now.
I have nothing further.
One thing too, within 2 minutes
Hold
of
on,
me
hold on.
being
Question
within
has
2
not
minutes.
been, objection, question has not been asked.
Okay.
Mr. Barry?
Yes. You were indicating, Mr. Green.
Thank you. I was indicated within 2 minutes of me being pulled over, a tow truck was already there towing my car. He ain't even hear nothing of my story. He took my license and he took my license and registration back to his police.
Listen, stop, Mr. Green. That tow truck is really irrelevant to the
But
charges.
within two minutes of somebody being pulled over,
It's
they car
irrelevant.
being towed.
It's irrelevant. It's irrelevant.
Okay,
And the
sir.
reason why
Yes, sir.
it's not relevant is because there's no it's no ticket for getting towed for two. It's just not relevant. That doesn't have any relevance to what the allegations of you driving while license suspended, driving no registration, and careless driving.
And indeed, Mr. Green, what was the status of your license at the time, as you understand it?
I thought my license was good. That's why I presented the officer with my license card. I never knew that my license was suspended.
All right. Let me ask you this, Mr. Green. You indicated to the court that you were in the middle lane.
Yes, sir.
And again, I know the area. I think I know the area pretty well. And
yes, sir.
At the area where you're speaking of, I believe there's a car wash right there on the corner of Davison on the northeast side of the road.
Yes, sir.
I didn't realize that that's just 2 lanes right there, though.
On Sunset. Well, let me let you
hold
talk.
on. Nevertheless, you say you're in the middle lane, and
Yes,
you
sir.
only went over lane of traffic. When you went over the 1 lane of traffic, you're saying that you noticed you were being pulled over, and you pulled right over after that. Is that what you're saying?
Yes, sir.
What street did you notice you were being pulled over? Where were you at that exact time?
A little passing Somerset, or let me get the right street name. Sunset, passing Sunset Street.
It goes Sunset, Dean, and Ryan.
Yes, sir.
And right when you were passing Sunset, you noticed you were being pulled over.
Yes, sir.
Trooper, is that the street where you initially, where did you initially initiate to turn your lights on to indicate that you were pulling this vehicle over?
At the time, it appeared as though he was approaching, I want to say Conant at that point.
We never made it past Ryan. We never made it.
Hold on, please.
Yes, sir.
And Your Honor, just for the record, I got a low battery here.
Hold on, please. Is there any video here or anything?
No, Your Honor, discovery was not requested in this matter. And there may be video, but we would need time to obtain it.
And that can be provided too.
Is your battery
the
dying
phone
in
is
your
about
phone?
to die here, just so you know.
Okay.
Yeah, just so you know.
Thank you.
And what is
If it
that
does die,
video?
I'll just pop back in.
What is that video going to show us?
Uncertain, Your Honor, at this time. I would only be speculating.
Why don't we get the video?
We can do that.
Why don't we come back and get the video? I think we dropped off the video. I want to be fair to both parties. I'm getting, two kind of it sounds as though both seem to be credible, but they're kind of two different versions. And if there's some video evidence that can help the court make a decision, I would like to see that. I would like to see an actual copy of the ticket as well. Did you get a copy of the ticket, Ms. Horn?
I do. Yep, I do have a copy of the ticket that I grabbed from the court's file.
And what does that copy of that ticket tell us? Because where the car was being pulled over.
I've got East Davison Street at or near Dean Street. And the trooper did mention that when the stop was initiated, they were at Dean Street.
I did, and that's why I don't go. That's why I don't. Hold on, sir. That's why I don't go off of ROAs, because on the ROA it says Dwyer Street, which is way up from this. So let's continue this. Mr. Green, I'm gonna continue this so that we can get the video of this and see what's actually. I want to get it right, and I think if we have some other evidence that helps us to get it right, let's view it and see where it goes from there. All right.
Yes, sir. I really appreciate you for doing your job the correct and honest way. I wish you a nice weekend. I wish everybody else. Thank you, my attorney Barry.
I gotta give you a date. Don't run off too quick. All right. That Ms. Horn, what do you say? Come back in 30 days?
I think that would work, Your Honor, because it's a little different process working with the MSP versus DPD.
All right, come back in 30 days. We'll continue trial at 8/3/2026. I would like to come back a couple of days before that. If we have video, let's come back a week before that with, if we have the video, so Mr. Green can view it. And we can just put him in a breakout room or something like that, and he can view that. And then so Mr. Green, you come back, the August 3rd date is good, but Mr. Green, come back on July 27th. You think we can get it by then, Ms. Sarn?
I'm hopeful. So 7/27/2026 at 9 a.m., Your Honor, for a final well, just a review until trial will continue.
8:30. Yeah, so you can review it.
Okay.
All right. That'll conclude that. So let your officer know August the 3rd for everybody. And Mr. Green, you come back on July 27th, 2026. Oh, I do have the copy of the ticket here. And a copy of it does say Dean and Davison. So that's why I'm going off ROAs. All right. Mr. Green, I swear I wish you would have taken me up on that offer, because it appears that you're not, I don't understand. You've gotten into more trouble in 16th Circuit Court.
I am getting in. I don't got no excuse. Becoming a young man, we taught to take responsibility for the choices that you make. So some of the choices that I made wasn't the best, but ultimately I am a good person at heart. Good.
That's what I listen. When I brought you up, I was talking to Wayne County Sheriff Raphael Washington. He was on my podcast a few weeks ago. And
do we want this on the record?
No, this is not on the record.
Okay.
When I brought you up, yeah, and I said that very thing that I didn't even give him your name. I didn't say your name, but I said this young man is a very good young man, I believe. And I was hoping that you would have come back and realized. I told him. I asked him, did he want to do that? He says, no, I don't want to do that because the police are this and that, and they do da. And I said, well, you can be the one to effectuate the change. But and then he comes back in.
I'm on the record. I'm sorry.
Then he comes back in the courtroom, and I asked him, is he working? He says, yeah, I'm working, Judge. I work in security. And I said, well, I tried to give you a Wayne County Sheriff job. And Judge, now I see you got extra.
I got a lot going on. I just recently purchased a land bank house. I'm in this land bank house as we speak.
And that would have helped you. That was a career.
With the way that my life been, I did all my own plumbing. I did all my own electrician. I'm becoming a young man. I'm doing right with my time.
Be careful. Do you have a license and requirements through BC? Might want to watch what you're saying.
Got you.
Well, yeah, but it's just, listen, sir, I wish you would have at least taken me up, because you can do all of that and be a plumber and I worked when I was at Ford. I worked in the afternoon at Ford. And then I got up every single solitary morning. This is long before I became a lawyer. I got up every single solitary morning and went down to my brother's office and worked there. So I worked there and then when I got in Ford, I got in journeyman's course. I worked at my brother's office. I went to trade school, and I went to work every day. And I raised 3 kids and on that. So it's not you. I wanted you to take the opportunity, because listen, first and foremost is a heck of a paying job, and it doesn't preclude you from doing other things. It definitely doesn't. And it's not something that you had to sign up for the rest of your life either. They have the best benefit package. You get a pension with them. You don't even know what a pension is. And how people would, especially people my age and people a little younger than me, where pensions have stopped, they would kill for that. and then you're still out here getting in trouble.
I'm sorry, Your Honor. Can you put me towards that, Your Honor, or is it too late?
I'm trying to put you toward it, but you're making it harder now. You're making it harder for yourself. I don't know what's going on in Macomb County. Yeah, hopefully it's something that you can get off of your record. But at the end of the day, you're making it harder, sir. So I will do the best I can to get you any opportunity that I see that's here and that's open. But you have to do something. And it's kind of simple. It's kind of simple. Stop driving without a license. Catch the bus if you have to. Get a ride if you have to. It's not, those are things that are not as convenient and as easy. But easy's not always the best.
Yes, sir.
You see what I'm saying? So I would love for you to come down here, spend the day with me, sir. Because I do believe you're a good young man. And we need a productive Mr. Green. I think
and I appreciate you, Judge. Do we need to recuse you?
Everybody in this room wants a productive Mr. Green.
Yes.
Including on the traffic stop, Your Honor. I think I mentioned this to this gentleman.
So, don't go out here thinking that people are against you. What you're trying to say is he already had his mind made. He may have already had his mind made up that he was going to pull you over and tow that truck. Because you know something, no, Mr. Green, is to be honest with you, half the people in the city of Detroit don't seem to have a license.
And Your Honor, if I might, I'll tell you this. If he thought I had my mind made up, I was on an overtime detail. I wasn't even thinking about pulling him over, but with his actions.
They're down talking. What's up?
Hold on. So don't go in this, don't leave out and go in this world. I mean, listen, we all got people against us all day, and we know that. With this color of our skin, we can't even go certain places in 2026. But if we sit there and harp on that, we're gonna miss out on other opportunities. I've seen, I've seen Trooper Hardaway before. I don't know what happened out there. That's why I want to get the video. I believe both of you are seem to be credible to me. I've already said that. But careless driving is not a hard burden. It's not a hard burden. And then driving while license suspended. All you gotta do is have a record. So listen, I invite you to come on down, Mr. Green.
What day are you free, sir?
Listen, I'm here every day. 8:15, I start up. You're more than welcome to come any day.
I'm gonna take you
and
up
I
on
will
your
turn you on to any resource that I have available to me.
Yes, sir.
All right, let's come back. Trooper, get that video to Ms. Horn. We're gonna allow Mr. Green to see that. We want to make sure it's there by July 27th. And then Trooper, we have you back on for this continued trial on August the 3rd, okay?
August the 3rd, yes, sir.
All right, everybody, have a very good rest of your day. Enjoy your weekends. Be safe. Enjoy your weekends. And one more thing, Mr. Green. I don't know what your friend group is like, but you know, I don't know if that has any influence on any of this other stuff, but it definitely it definitely affects you the people that you are around.
It does. It does.
Definitely. So, hey, you really gonna find the friends that you thought were your friends? You just, when they say you don't have many friends out here, you don't. So, that's the last thing I'll leave you with before I just tell you guys to have a very good weekend. Okay.
Thank you. Hope you too.
All right. Best of luck to you all. All right. And be safe out there, trooper.
Will do. Take care.
Take care, everybody.
All right,
Thank you for being patient, Mr. Wadeski. We're going to call your case next. This is the state of Michigan versus Timothy Wadeski, file 25-6791-FH. This is a probation violation hearing on sobriety court matter. Mr. Hamlin is with us. Mr. Dick is with us. The prosecutor, Mr. Fortier, is here, and Officer Gertz is with us as well. Mr. Dick, how does your client wish to proceed today?
Your Honor, Mr. Wadeski, I believe, would like to be able to address the underlying allegations. Mr. Wadeski, if that's not accurate, please say so, and I will request that we have a brief breakout.
Does that mean that he wants to give an explanation, or does that mean he wishes to have a hearing?
Sorry, Judge. My apologies. I believe he still wants to have his hearing today.
Is that correct, Mr. Wadeski?
Sorry.
Yes, Your Honor.
All right. Let me remind everybody what the allegations are, and then I'll ask Mr. Fortier to proceed, and Mr. Hamlin to proceed with their proofs. Starting from the oldest to the most recent, there are, all right. On March 12th, March 12th, 2026, the allegation is that there was a no-show for counseling appointment with Bear River Health. March 22nd, the allegation is that there was a no-call, no-show for a drug screen at Great Lakes Screening and Services. On March 26th, the allegation is there was a no-call for a drug screen at Great Lakes Screening and Services. On April the 10th, 2026, the allegation is a no-call for a scheduled drug screen at Great Lakes Screening and Services. Oh, looks like I skipped one. March 31st, 2026, failure to complete community service as per the phase requirements and or failed to abide by the workers' work camp contract to assist in paying off fines and costs. And then finally, May the 11th of 2026, the allegation is that there was assault on hospital staff at Otsego Memorial Hospital and later assaultive activity towards local law enforcement, and that arrest warrants were issued and he was lodged at the county jail on May 22nd. Those are the allegations that have been made against you, Mr. Wadeski. Mr. Fortier, how do you wish to proceed with this?
Your Honor, what I would like to do is address the May 11th issues first, just so that we can get Officer Gertz and Sergeant Prey on our way.
Be happy to do that. Officer Gertz, would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
All right. Thank you very much. Go ahead, Mr. Fortier, as you're questioning.
Thank you. Officer Gertz, where are you presently employed?
At the Gaylord Police Department.
And what's your current capacity there?
I'm a police officer.
Okay. Were you working on May 11th of this year?
Yes, I was.
Did you come into contact with Timothy Wadeski on that day?
Yes, I did.
What did you come into contact for Mr. Wadeski?
Myself and Officer Depew were contacted by Otsego Memorial Hospital and informed that they were going to tell Mr. Wadeski that he is going to be placed for treatment based on prior contacts. They want law enforcement there as he has been aggressive with staff and has threatened to leave when this has happened before.
All right. And when you showed up to the, you showed up to the hospital? Is that right?
Correct. Yes.
All right. And did you see Mr. Wadeski when you got there?
Yes.
What was his demeanor?
As we got there, the doctor informed Mr. Wadeski that he was going to be placed for treatment. Mr. Wadeski appeared very agitated with that and verbally advised that he did not want that to happen. We attempted to verbally de-escalate the situation, which continued to rise, and where he began to demand his phone as he had to make phone calls to set things up. We attempted to work with Mr. Wadeski as long as he complied with staff as far as sitting down and trying to calm down. Those attempts did not work, and during that there were several threats to law enforcement and staff that he would do whatever he wants and to be able to get to his phone. He referenced past resisting arrest charges that he has and saying that it would take more officers to restrain him if it became that type of situation. During all of these comments, he did begin banging on doors, kicking cabinets, where hospital staff determined that he was going to be restrained. When that was going on, one of the troopers arrived on scene. Once inside the room, the trooper did have his taser out based on threats towards law enforcement that may become a physical altercation. And during that, Mr. Wadeski was walking towards the trooper. At that time, I took Mr. Wadeski to the ground. We continued to resist. Officers were able to gain compliance through pressure points and physically restraining him and place him into soft restraints.
All right. And just kind of backing up a little bit, when you said he was banging things and seemed to be breaking things, what was that about?
There's a metal roll down door within that hospital room. He was banging out with both fists. He was kicking a lower cabinet to that, which at one point did break off the hinges, and he did pull off, having in his hand when we entered the room. With being a potential weapon is when the taser was then brought out of a holster. To if there was a weapon that we would may have to deploy that. Mr. Wadeski did make multiple comments towards tasers, saying we may have to use them, and even have to use a firearm potentially.
Okay. And how many officers did it take to eventually get Mr. Wadeski restrained?
By the very end of it, it was 5.
And was he struggling the entire time that you guys were trying to get him restrained?
Correct. He was constantly pulling away from us, trying to push us. He did kick one of the officers.
Okay. Are you aware of any charges that arose out of this incident?
I did submit up charges for counts of resisting an arrest and felony destruction of property for the damage to the room.
Okay. And are you aware if an arrest warrant was actually issued on those?
Yes, it was.
And I think that's all the questions I have for you right now.
Mr. Dick, cross-examination.
Your Honor. Sorry, I'm plugging in my computer. I mistakenly showed up at court because I was feeling detached from everybody. All right, so Officer Goetz, when you at the hospital, did you have any, were you briefed by as to any sort of medication that had been administered to Mr. Wadeski?
No, I was not.
Okay. So did you later find out during any sort of investigation whether he had been administered any sort of medication prior to this interaction with him?
During the interaction, he was provided a medication. I'm unsure what it was, in attempts to calm him down. Mr. Wadeski said multiple times that it's not going to work and that he has taken whichever one it was multiple times before. The staff did offer other types of medications, including antipsychotics, and he denied all those medications.
Okay, but did you find out later on whether or not he had been administered any other medications?
No.
Prior to your engagement? No. Okay. Based on your training and experience, let me rephrase that. Based on your training and experience, did Mr. Wadeski appear to be in some sort of a distressed state?
He seemed very upset about the situation. He advised staff that he was there seeking help, and the help that he wanted was medication, and that he very much did not want to be placed into a treatment center.
Okay. Did he appear to be coherent at that time?
Yes.
Okay. And was Mr. Wadeski responsive to, in your opinion, was Mr. Wadeski responsive to your direction? Or
no.
Was it? Okay.
He was advised multiple times to sit down, which he would not do. There was once where he sat down for a couple seconds, but he was advised multiple times to sit down, and we attempted to verbally de-escalate the situation before I had to go any further.
Okay. Do you believe that he was able to, based on your training and experience, believe that he was at that time able to understand and react appropriately to your direction?
Yes, I believe he would have been able to.
Okay. At any later time, was there as part of your investigation or the investigation, was there a blood analysis perhaps of what might have been in his system at that time?
There was not.
Okay. All right. I guess at the present moment, I have no further questions. Thank you.
Any follow-up, Mr. Fortier?
No, Your Honor.
All right, can Officer Gertz be excused?
He can.
Mr. Dick?
Yes, Your Honor. He said no to what I would have needed to ask him anyways.
All right.
Yeah.
Your next witness, Mr. Fortier?
Sergeant Ryan Prey.
Sergeant, would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Do.
All right. Your witness, Mr. Fortier?
Thank you, Your Honor. Sergeant Prey, where are you presently employed?
Gaylord City Police.
And what's your current job description there?
Road patrol.
All right. And how long have you been with the police department?
13 years.
All right. Were you on duty on May 11th of 2026?
Yes.
Do you recall being dispatched to the Otsego Memorial Hospital for an incident involving a patient and a security guard?
Yes.
Can you tell me about that?
We had been told that Mr. Wadeski was at OMH and that there had been some issues with night staff. And later that shift, I was dispatched for an assault on one of the security staff. I made contact with Andrew Goebel. He's a security guard at OMH. He informed me that Mr. Wadeski had exited his room, and he and another security guard had attempted to escort him back into the room, at which point, or when they got into the room, Mr. Wadeski grabbed the security guard, pulling him down onto the bed, put his arm over the back of his head and like under his chin in a modified chokehold. And the security guard informed me that before Mr. Wadeski could lock in the chokehold, he was able to escape. And then they put him in soft restraints. That's the point I walked in when he was being restrained in the bed.
Okay. And did you have the opportunity to review video for that?
Yes, I did.
What did that video show?
Mr. Wadeski was out approximately 10 feet out of the room talking to a security guard. They, both security guards were there. They escort him back to the room. He reaches out towards, I believe it's Mr. Goebel is his name. He pulls him down onto the bed, and he may have hit him first. I can't recall
off the top of my head, but he definitely pulls him onto the bed on top of himself and wraps his arm around the back of his neck to under his chin and in a chokehold. And then shortly after, the security guard pops his head out, and then they place him back on the bed and restrain him.
Okay. And are you aware if a felony warrant was issued as a result of this particular incident?
Yes, there was.
All right. And are you aware if Mr. Wadeski was taken into custody on that warrant?
I believe he was taken into custody on the 22nd of May.
Okay. Sergeant Prey, I don't have any further questions for you at this time.
Mr. Dick, cross-examination.
Yes, Sergeant, on the date of this incident, you responded to the initial dispatch call. Is that
Yes,
correct?
Sir. Yes, sir.
And is it correct that this incident happened in the emergency room?
Yes, sir.
Okay. And Mr. Wadeski was a patient there, correct?
Yes, sir.
Okay. And do you recall, dispatch did state that the hospital staff were seeking to place him into a mental health facility, correct?
I don't exactly recall the exact words dispatch used, but at some point I did learn that.
Okay. Then, so when you arrived, did you have an understanding that this was a type of mental health or medical situation, not just like a routine traffic stop, for instance?
Yes, sir.
Okay. And hospital staff was already, and their security was already involved before the police contact with Mr. Wadeski, to your knowledge, correct?
As far as tying him down or just keeping him?
Anything in general.
They were standing by the room. I know that.
Okay. And were you one of the law enforcement officers who took Mr. Wadeski or helped detain Mr. Wadeski?
Are you referring to the incident with Officer Gertz?
Yes, I guess.
Officer Gertz incident happened at like in the morning of the 11th, and mine was at 5 o'clock at night on the 11th.
Oh, understood. My apologies. Yes, I think I was. Okay. All right. So during your incident, were you aware that Mr. Wadeski had been administered sedation previously?
I don't recall. I know generally they won't tell us the exact medication. They'll say they gave him a shot to calm him down, and I don't recall if that was this incident or previous.
Okay. So you were not an eyewitness to the original in the emergency room incident then?
I wasn't witness to either of the incidents in person, no.
Okay. All right. Do you know whether Mr. Wadeski was ultimately petitioned into mental health treatment following this incident?
No, I don't know that.
Okay. But you knew that it was a suicidal patient medical crisis setting?
I knew it was basically a psych patient.
Psych patient, okay.
Yeah.
So mental health or psychiatric emergency room situation.
Something to that effect.
Right. Okay. Okay. And from what you saw, Mr. Wadeski was only wearing, well, he wasn't wearing his prosthetic, correct?
Correct.
And so he was moving around not under normal circumstances.
He hopped his way out of the room and they escorted him back. There was one on each side helping him back into the room.
Okay. But based on the investigation, it appeared that the staff and the officers knew that he was being medically treated for mental health issues.
Yes.
Okay. So as part of the investigation, are you aware whether sedation or medication effects were ruled out as a possibility causing these circumstances?
I was not aware of that at all. He was just not being compliant with staff and attempted to choke a security guard.
Okay. All right. Let's see. Sorry. So your affidavit says that he was in the emergency room because he made suicidal statements, correct?
I'm not 100% sure. I don't have it in front of me right now, and I only had a few minutes to prep for this.
Well, understood. And all right. So before submitting that charge, did you rule out medical incapacity for the assault charges?
I mean, he seemed very capable of making decisions. I've dealt with Mr. Wadeski several times, and even when he is in the hospital, he responds as if he knows what you're talking about and he's following your line of thought when you are talking with him. He's not outside of a normal capacity, I guess, if that makes sense.
Okay. But he did seem to be in some sort of like disorder or panic, correct?
He was upset, but it's a state that I've seen him in several times in the past.
Okay. During those prior incidents, was he under the influence of some sort of like medically administered sedation or things of that nature?
Either medically administered or self-administered.
Okay. All right. I have no further questions. Thank you.
Any follow-up, Mr. Fortier?
No, Your Honor.
May this witness be excused?
He may.
Yes, Your Honor.
Mr. Dick? All right, thank you, officer. Appreciate your
Thanks,
time. Mr. Fortier, any other witnesses or evidence?
Probation Officer Luke Hamlin.
Officer Hamlin, would you raise your right hand so I can swear you in, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
You.
All right, thank you. Your witness, Mr. Fortier?
Mr. Hamlin, where do you presently work?
I currently work for the 87A District Court here in Otsego County.
And what's your job title?
My job title is the Drug Court Probation Officer.
All right, and what are your duties and responsibilities in the role?
My duties in the most simplest and quickest way to say this is to monitor probationers at a very intense pace and rate, Monday through Friday, with a lot of things directed towards counseling, drug screens, and overall attitude during the course of the week or thereafter.
All right, and do you currently supervise an individual named Timothy Wadeski?
Yes, I do.
And is he on, I guess what we would call drug court probation?
He is currently on my caseload, yes.
Okay. So what are essentially some of his requirements that he has to do as part of that probation?
Well, currently Mr. Wadeski is in the third phase, so his requirements are reporting twice a week, both Tuesday and Thursday, which includes random drug screens. That could be anywhere from any day of the week or every day of the week to maybe not testing until on a 10th day of a certain week. He's also got counseling that he has to abide by, group therapy he has to abide by, going to AA meetings no less than 2 times per week, going to the court for his drug court review hearings twice a month on the 2nd and 4th Tuesday of each month.
All right. And what are, for the drug screens, is there a process for that?
Yes, the process for that is every day, Monday through Sunday, between the hours of 4 a.m. and 7 a.m., you make a call to what's called the Redwood testing line. The participants are given a phone number, they have a PIN number. That number indicates if they have to take a drug screen or not. If they do, they have to report over to Great Lakes Screening and Services here in Gaylord, which their window of drug screens are between 7 a.m. and 8:30 a.m. There is no specific time they have to show up, but they have to show up in that window.
All right. And what about counseling requirements?
Counseling requirements vary given each phase. I don't have those documents in front of me. If the court does allow me, I can look those up, but each phase has a certain amount of counseling requirement, both individual and group, that they have to attend.
Okay. So Mr. Wadeski is required to attend counseling though?
That is correct.
Okay. So I want to direct your attention to the paperwork I'm showing kind of starts back on March 8th of 2026. Did Mr. Wadeski have to call in that day for a drug screen?
I don't have March 8th in front of me. I have March 12th.
Okay, so let's
the
start with
allegations started March 12th.
March 12th. Okay, so March 12th indicates here that he was a no-show for a scheduled appointment with Bear River. Can you tell me about that?
I reached out to his counselor, and it's been some time since we spoke, but he was a no-show according to his counselor. She reached out to him asking where he was or what he was doing or something to that effect. And it took him some time to get back to her. Could have been a half hour, maybe an hour tops. But he indicated something to the effect he was sick and wasn't able to attend counseling today.
Okay. And this was for March 12th.
Yes, March 12th.
Okay. And does it sound about right that you weren't aware of this until April 8th?
That's correct. The reason I wasn't aware of it was every month we get invoices for counseling, and in those invoices it indicates who was a show or who was not a no-show.
Okay. If people who are on drug court probation, specifically Mr. Wadeski, if he misses, say, a drug screen, or if he misses a counseling appointment, or if there's an issue with it, is he required to contact you and let you know about those circumstances?
We're required, it's a tough word for me to answer, but he should, because the program is about accountability and honesty. So he should report the incident.
Okay. And on March 22nd, 2026, was Mr. Wadeski required to do a drug screen that day, or to call in for a drug screen that day?
Yes, again, every day, Monday through Sunday, weekends, holidays included, yes.
Okay. Did he call in on March 22nd, 2026?
He did not call in on that particular day.
Okay. Did he notify you that he didn't call in that day?
Judge, can I have a minute to review the paperwork?
Certainly.
Can you ask your question again, Mr. Portier?
Yeah, so did Mr. Wadeski notify you on March 22nd that he didn't call in?
He notified me after his release from jail that he didn't call in because he was under the assumption that, I can't remember the words we used, start fresh, start new the following week.
Okay. And then on March 26th, did he call in that day to see if he had to take a drug screen?
That particular day, he did not.
Okay. Did he show up that day still to take a drug screen?
If the sanction report just says he was no call, that's all he was. So that would indicate he did show up if he had to, but without looking at my paperwork, I can't specifically say.
Okay. I'm looking at the all sanction report. Just about the note that's in here on March 26th. If taking a look at that would help refresh your recollection, or do you think looking at that would help refresh your recollection?
The judge allows it.
Go ahead.
It's the second to last page on your all sanctions report, Mr. Henley.
If you're looking at the significant indicators of the report, Mr. Portier, in bold.
I believe that's the section it's under, yeah.
All right, can you ask your question again, sir?
So did he show up on March 26th to take a drug screen? Or sorry, did he eventually call? Is what I should have asked. I'm sorry.
No, I'm understanding. He did call, but it was after the time of the 7 a.m. cutoff line for the drug court policy.
Okay.
And
go ahead.
He was talking to me during a scheduled office visit, indicating that his phone was on an update throughout the course of the night. When he woke up, the phone had updated and he was calling past that time.
All right. And when people are placed into drug court, do you go over the policies with them?
Yes. Go over the policies, go over what happens if the phone lines are down and or if your phone isn't working. Your phone isn't just subject to be the only phone to call that drug screen line. Any and all phones can call that drug screen line so long as you're able to type in your PIN code.
Okay. And on April 10th, did he call for his to see if he had to drug test that day?
He was a no call on that particular day, sir.
Okay. And Judge, was there also an alleged sanction violation on March 31st? Is that another one of those days?
That is correct.
Okay. Mr. Hamlin, on March 31st, was there an issue with Mr. Wadeski in completing his community service?
Correct.
So what is required of participants in the program as far as community service goes?
Mr. Wadeski is a unique situation. He signed a community service contract to assist in paying off his fines and costs with the court for his current charge. So I, as his probation officer, kind of forgave the community service per phase requirement and just focused on fines and costs as per that contract with the court.
Okay. And did he comply with that aspect of it on that for that month of March?
He did not.
And you've instructed Mr. Wadeski on all of his requirements in the program, is that right?
Many times over.
And does it sound about right that Mr. Wadeski's been in the program since January of 2025?
Negative. That's an incorrect date.
Okay, how long has he been in the program?
He's been in the program since November of 24.
Okay. So between November of 2024 and all of these sanctions kind of beginning March 12th, you've instructed Mr. Wadeski on what he's required to do.
Yes.
And that's, you said, something that you've done regularly?
Yes.
Are the participants given like a policy manual or anything?
Yes, they're given both a drug court handbook. They're given instructions on how the Redwood testing line works and or operates, and they're also given policy on the sanction protocol with our court.
Okay. Your Honor, I don't believe I have any further questions for Mr. Hamlin at this time.
Thank you. Cross-exam, Mr. Dick?
Yes, Mr. Hamlin, the March 12th no-show for his for Mr. Wadeski's counseling with Bear River. Mr. Wadeski provided you with a doctor's note for missing that counseling session, correct?
Do I have that added on to the sanction?
Pardon me?
Do I have it added on to the paperwork?
I do not have a copy of it.
Judge, if I may look.
Right.
You may certainly review your records, Mr. Hamlin.
Thank you. So any and all paperwork that I have attached to the sanction dated March 12th of 2026 is the only paperwork I've received from Mr. Wadeski.
Did you happen to have anything in your notes about the doctor's note for that date by chance?
My notes that are reflected in the system that I use for drug court, sir?
Yes, I suppose.
I don't recall putting any note for any doctor appointment there.
Okay. All right. As per the drug court counseling policy, would a participant be able to miss an appointment if they were to provide a doctor's note for an illness? Pardon me.
It's somewhat twofold. One, contacting your probation officer and telling the probation officer I'm too ill to make it to counseling today. And number two, definitely getting a note from a doctor and providing that said proof to your probation officer. A counselor simply cannot just omit somebody from counseling because they told them they're too sick to be there today. It's definitely required proof that you're too ill for an appointment.
Good. All right. On March 22nd, the no call to the testing center. You had mentioned that Mr. Wadeski thought he had some sort of fresh start on the Monday. What was that? Did Mr. Wadeski show you his book and show you an entry stating that?
No, Mr. Wadeski and I discussed, I can't remember if it was before him going to jail or after he got out of jail. We did discuss the incident, and to my recollection, it's something about before going to jail that once he got out, he does start fresh and new. But that didn't excuse any call to a drug screen line or any other authority he had to hit.
Good. Did you did you explicitly tell him he had to comply with all continued requirements for the drug treatment program after he was released, including sorry, that's going to be a compound question. Go ahead.
Understand your question, but given the times that Mr. Wadeski and I spoke about drug court and its requirements, I think the best answer would be presumed that drug court doesn't stop, because that's something I do tell the participants very routinely, is this program never stops.
Okay. The fact that the Fresh Start was discussed at some point, did in your mind, is it possible that that could have been misconstrued?
Yes.
Okay,
I
thank you.
would say your argument there is very accurate.
Okay. And moving on to the March 26th no call. You had stated that this was a late call. Is that correct?
Yes.
Okay, and he did test that day. Okay, and then March 31st failed to complete community service as required per phase requirements, or fail to abide by the work camp contract. That violation. So did Mr. Wadeski, actually, what were the hours required by Mr. Wadeski to complete by March 31st?
I believe he and I worked it out so that he was going to work camp 1 day a week, which would be 8 hours every week to assist paying off his fines and costs.
Okay. And this particular one, do you recall oops, my apologies. 1 moment. Do you recall what day of the week March 31st fell on?
I don't recall what day of the week March 31st fell on, but if I may explain the reason why I wrote the violation, I'd be happy to do so.
Yes.
I think it's imperative to notify the court that Mr. Wadeski has not paid on his fines and costs in some time. Mr. Wadeski has not done the community service as per the Otsego County Work Camp contract. It's my obligation to advise the court that little to nothing was completed, as it's part of my duty and responsibilities as a probation officer to do. So that's the only reason I wrote this violation, again, just to bring it to the matter of the court.
You know, I don't do this often, but when somebody comes along and donates 100 cold, hard American dollaroonies on the 250th anniversary of this great nation, I just have to stop and say, thank you. Thank you for joining the celebration. Thank you for being here. I love you and you're amazing. And I can't say thank you enough. And while I'm here, I just want to say, hey, we've been here well over half of the time that we're allotted. And thank you all for hanging out. It's really, this is an amazing hangout. We rarely go this long, and we still have an hour and 15 minutes to go, I believe. No. We got an hour and a half to go. So we still have a feature-length movie ahead of us, ladies and gentlemen. I'm your lone wolf Usul and Vega Starlight. Thank you so very much for your contribution. I don't even know. I'm stunned. Guys, toast all around. Toast all around to Vega Starlight. And the United States 250th 50th anniversary. Happy 4th of July, everybody.
Okay, so the is this violation, is it reflective of not completing community service on March 31st or in that week of March 31st?
Again, I don't have the calendar on me, but I would suspect it'd be within the week of March 31st.
Okay, so if I, all right, do you recall when he next completed work camp, his 8-hour day?
There hasn't
After-
been any completion since that sanction was written up.
Okay. All right. And then the April 10th no call, it was just a no call for the testing center, correct? All right. All right, no further questions, Your Honor.
Any follow-up, Mr. Fortier?
No, Your Honor.
All right, you may step down, Mr. Hanlon. Mr. Fortier, any other witnesses or evidence?
No, Your Honor.
Mr. Dick, witnesses or evidence?
No, Your Honor.
Closing statement then, Mr. Fortier.
So, Judge, I think based on the testimony that's been presented here today, there's been a preponderance to show that Mr. Wadeski has violated the drug court program policies by not showing up for his counseling. We heard Mr. Hamlin say that the counselor actually had to reach out to him to find out where he was at. And then he just said, I'm sick. Can't come in. Didn't tell Mr. Hamlin about it. He had to find out when he was processing invoices. He's consistently not calling in for his drug screens. And seems to always be some sort of excuse. The phone messed up or it updated and it did this, and good old fashioned alarm clock probably could have helped. And I think it was Mr. Hamlin that indicated that more than one phone can call the line. They have a pretty significant window to call in from 4 a.m. to 7 a.m. March 26th, the same thing, didn't called past the cutoff time at 7:31. March 31st, he was, failing to complete his part of a bargain to try to help pay off fines and costs. I don't know that how many hours or whatever he was supposed to do, but it sounds like from Mr. Hamlin's testimony, it was quite significant. At least sounds like maybe 8 hours or so. And then on April 10th, no call, no show for the scheduled drug screen. So I think it's consistent. It's not showing up for counseling, not showing up for his drug screens, or not calling in for his drug screens. And then culminating with these events that occurred on May 11th of this year, where he's in the hospital, he's demanding certain drugs. The hospital's not wanting to give him those drugs. They want to give him something else as medical professionals, and he's refusing it. He's getting testy. It takes 5 officers to hold him down after he's destroying hospital property. He's kicking at one of the officers, kicked him in the chest. Having tasers pulled on him. It just shows his behavior is just continuing to elevate into violence. And then, shortly after this incident, the very same day, he's on hospital security camera, fighting with security guards and pulling one of them down onto the bed to try to choke him. And thankfully that officer was able to get free and they got him restrained into the bed. Those charges are both pending. They've been bound over to the circuit court. There's pending resolution in the circuit court. But I think the totality kind of shows that Mr. Wadeski has repeatedly violated the terms of drug court policy. And based on that, I would ask that the court find that he has violated it. Take into account that he's got 7 prior sanctions on top of the numerous prior dismissals that the court has given him chances to basically make amends. And he's continued to do the same thing over and over again. So I would ask that the court unsuccessfully discharge him and have him placed back in front of the sentencing judge, which would be your honor. You sentenced him in January, I think it was January 25th of 2025 was when the judgment and sentence was signed for further hearing on what should happen to him if he's discharged.
Thank you, Mr. Portier. Mr. Dick, your comments?
Yes, Your Honor. As it pertains to the specific violation or allegations that the prosecution was not able to sustain their burden, I would say that, well, pardon me, let me take that back. I would argue that at least the March 22nd no call, there was a discussion with the probation officer, and he acknowledged that their conversation may have been a misunderstanding of whether or not a call needed to be made on the date of the 22nd after being released from jail on the 21st. I would ask that particular allegation be dismissed, Your Honor. The March 12th no show for the scheduled appointment. Excuse me, counselor acknowledged that Mr. Wadeski did respond, letting her know that he was in fact really sick, and Mr. Hamlin was also informed of that, although later on after inquiring about it. The March 26th no call, Mr. Wadeski did in fact test, although his call was according to Mr. Hamlin shortly after the required deadline for the calls. As for work camp, the completion of that Mr. Hamlin did make a statement that it was not completed. So I will not address that any further. Likewise for the April 10th no call, Your Honor. The May 11th incident, Your Honor. So for a person to generally culpable of this of an offense, or even like the probation violation here, Mr. Wadeski would need to have been able to know what was being done or what he was doing, or know that the officers were acting with legal status or legal authority. This particular incident, it was a mental health incident. Both law enforcement officers did testify that They did respond to the hospital because of the individual being there on some sort of a medical health issue, mental health issue, and that Mr. Wadeski was being ultimately petitioned. Your Honor, the fact that he was being petitioned and not voluntarily admitting himself for the mental health treatment, it does reflect that he was not coherent of the incident, not understanding of what's going on. Your Honor, for him to violate the drug court policy or this particular incident, he needs to knowingly have acted in this matter. I believe that the preponderance of the evidence weighs against the Mr. Wadeski being coherent of the situation. The officers did not know whether he had been administered any sedatives or medication prior to the other officer's arrival. There was the acknowledgement of some additional sedatives being administered during the scuffle. And Your Honor, I think that in this particular incident that the court should find that this did not, or sorry, the prosecutor did not meet the burden on that particular allegation. That being said, I do know that Mr. Wadeski has put in much effort here in the treatment court. I do not believe that the court or anyone else would say otherwise. And I think that Mr. Wadeski, if nothing else, he's honest, and he himself would say that there have been some struggles throughout this entire process. Yeah, I'll save it for any. I guess the other thing that I would like to just mention is that he seems to have done pretty well for somebody who has been struggling so much with his mental health and addiction. And I think that I ask that the court would consider all of that also in deciding what to do with Mr. Wadeski. Thank you, Your Honor.
Thank you, Mr. Dick. As to the allegations specifically against Mr. Wadeski, the burden of proof of the probation department is by a preponderance of the evidence. I have considered the testimony of Officer Gertz, Sergeant Prey, and Probation Officer Hamlin, including cross-examination of them. As to the March 12th, 26 allegation that there was a no-show for a counseling appointment at Bear River, I do believe by a preponderance of the evidence, there was a no-show for that. Mr. Wadeski claimed that he was sick to the counselor, but as Mr. Hamlin testified, counselor is not able to relieve him of that duty and requirement to report to counseling as required. And I would simply point out, as I'll make a record of this in just a minute, as to his violation history, there are approximately 18 or 19 different allegations against Mr. Wadeski from starting in December of 2024 through beginning of March 2026. most of which were ending in a violation or a combination of violations, some of which were dismissed, but all of them involving either a no call or a no show. So it's very clear to me that Mr. Wadeski on multiple prior occasions was informed of the requirements for calling and showing up, and knew very well that simply claiming to be sick without proving it by a doctor's note and by contacting his probation officer would not be sufficient. So I do find by a preponderance of the evidence that he's committed the violation on March the 12th. On March 22nd, the allegation is that there was a no call, no show for a drug screen at Great Lakes. And this is the one where counsel asks me to find that there was a misunderstanding, that it was a fresh start. And again, for the same reason that I noted the previous violation, there's been approximately 18 or 19 of these no call, no shows, either for counseling or for his drug screening process. So he knew very well what the drug screening process was. And to say that even if an offhand comment of a fresh start is made, that stops you from having a duty to report when you're supposed to report or call when you're supposed to call, it simply boggles my mind given the amount of time and effort and energy that we put into Mr. Wadeski under these same or similar circumstances in the past. So I do find by a preponderance of the evidence that he was a no call, no show on March the 22nd of 2026. On March the 26th of 2026, again, the allegation is he was a no call for a drug screen at Great Lakes Services. This is when he did show up, did call, but he called late. And again, his history of problems with this, he was told in court a number of times by myself. I know that he's had this same conversation with his probation officer a number of times about when he's supposed to call and under what circumstances he's supposed to call, and that there is a hard line at 7 a.m. And he's been, I believe, had violations for this exact same thing in the past. So I believe he knew that, and so I do find by a preponderance of the evidence that he did fail to call within the time frames on March 26th. So I find that violation has occurred as well. On March 31st, 2026, the failure to complete community service per the contract. The contract was given to Mr. Wadeski individually and very specifically so that he could have an opportunity to pay off his fines and costs, because he was having some difficulty with his employment and his treatment programs. And we were working with him to a very great extent on to make sure that he could attend his inpatient treatments that he went to in, I believe, March and April of well, I got the dates wrong on that, but there was a time period when he left the program and we didn't require him to do anything because we knew that he was in inpatient treatment program, both for his mental health and for his substance abuse. And so we gave him an opportunity to come back into the program and continue to work through the work camp, and he was supposed to report once a week to that. And so that process was made very clear to him over a number of different time frames, and he failed to complete the community service as required and hasn't made a payment since. So I do find that violation has occurred as well on March 31st. On April 10th, there was a no call, April 10th to 26th, a no call for a scheduled drug screen at Great Lakes Screening and Services. And again, for the reasons I've indicated in the past, I believe that Mr. Wadeski was very well aware, and there's approximately 18 times in the past that he's been sanctioned or talked to about it in court or with the probation officer. So it's very clear to me that he knew what he was doing and he failed to call and is responsible by a preponderance of the evidence for the no call on April 10th. And then finally, the one that concerns me the most is the allegations of what occurred on May 11th at the Otsego Memorial Hospital, both at the morning incident with the police officers for resisting and obstructing, and for the evening incident, which occurred with the choking incident of hospital staff. I find that the testimony of the police officers is highly credible, was sufficiently detailed to allow me to understand what happened there. And I find that the backup of the video that Sergeant Ryan Prey viewed that confirmed in his eyes what occurred with the choking incident, all shows me that physical incident occurred. Defense counsel has argued that while the physical incident may have occurred, Mr. Wadeski, who struggles with his mental health and has struggled over a long period of time with his mental health, simply didn't know what he was doing or was not, should not be held responsible for what he was doing. But unfortunately for Mr. Wadeski, the testimony was that he was not acting violently, or at least as much violently, before he was told that he was going to go to inpatient treatment. And the violence that was testified to by the officers occurred only after the staff at the hospital informed him that he was going to go to inpatient treatment. And then it then escalated, and Mr. Wadeski was making threats to the police officers and to the staff. Was breaking things in response to that. Had a very violent and long-term violent reaction to that over a number of minutes, and to various officers, including those who had had to pull tasers out to try to get him to respond in an appropriate manner. So it does not appear to me that he was suffering from a mental health incident as much as he was having an anger management problem. And while his mental health may have exacerbated or led to him coming to the hospital, it did not prevent him from understanding what he was doing, that he was escalating in a very violent manner, and could very well have hurt other individuals. And that conclusion is bolstered by the fact that it did not just occur once, but he acted out in a violent manner much later in the evening and had to be returned. He was taken off of the restraints and then had to be returned to the restraints when he choked or attempted to choke out one of the security officers at the hospital. So for all of those reasons, I do find that Mr. Wadeski is responsible by a preponderance of the evidence for a violation of his probation requirements as to the May 11th incident as well. The question then becomes, what do we do about all of this? And so that anyone who's reviewing this, if there's ever an appeal, understands, I'm going to read through the sanction report history just to put on the record all of the things that we've attempted. We found Mr. Wadeski to be in violation for, and those that we have bypassed or dismissed in trying to get him to comply voluntarily. And basically it boils down to every single month that he's been in the program, all the way back from beginning in December, the month after he was allowed to start the program in November 22nd, through the end of this May 11th violation. Every single month he's had a violation of some kind, or at least an allegation of a violation of some kind or another. So he was put on probation on November 22nd. December 5th, he was a no-show for a drug screen at Great Lakes that was dismissed by Judge Cooper. December 27th, he was a no-call, no-show for a drug screen. January 10th, he was a no-call for a drug screen. February 7th of 25, I dismissed a no-show for a scheduled drug screen. February 8th, I dismissed a no-call, no-show for a drug screen. He was on February 15th, he was a no-call for a drug screen. February 20th, he was a no-call for a drug screen. March 28th, he was a no-show for an office visit. April 23rd, no-show, I dismissed that for a drug screen. May 7th, no-show for a scheduled drug screen, I dismissed that. May 7th, late for a scheduled office visit, I dismissed that. May 9th, failed to bring his medication for review, I dismissed that. May 19th was a no-show for a scheduled office visit, I dismissed that. May 26th was a no-show for a scheduled drug screen, I dismissed that. May 28th was a no-show for a scheduled drug screen, I dismissed that. The June 5th was a no-show for a drug screen, I dismissed that. June 7th was a no-show for a drug screen, I dismissed that. July 15th was a no-show for counseling. August 11th, he was arrested on a warrant for larceny in a building and habitual fourth, and subsequently pled to that. In August through November, he was in treatment outside the drug court program, and we allowed him to do that so that he could best meet his mental health needs. No sanctions were taken for him, even though he missed a number, approximately 9 no shows for office visits and for drug screens, but we knew that he was in treatment, so we didn't take any action as to those. However, once he was released from treatment, on November the 11th, he was November 23rd, he was a no call for a drug screen at Great Lakes Screening. December the 4th, he was a no show for individual counseling. January the 11th, a no call and no show for a drug screen at Great Lakes. February 15th, a no call and no show. I dismissed that. March 8th and March 9th, he was a no show for a drug screen at Great Lakes Services, and that brings us to the 6 violations that he had today. So every single month for the last 16 or 18 months, he's had a violation of the drug court policy in one form or another. And I just can't have him in the program if he's not going to be able to meet those requirements. In addition to that, this is his second time while in the program that he has either been convicted of another crime or been charged with another crime. The first one was the larceny in a building on August 11th of 2025, about a year ago. And he's now escalated to, rather than just larceny and property-related crimes, to the allegation is now, that I found by a preponderance of the evidence on today's record, that he's committed multiple assaultive behaviors towards not only law enforcement, but hospital staff who are trying to assist him in his treatment. So for all of those reasons, I am going to grant the prosecutor's request to dismiss him unsuccessfully from the drug court program, and we will set a resentencing date once a pre-sentence investigation has been done, and that will be set by the court. Anything further today, Mr. Gauthier?
Yeah, regarding an updated PSI, do you want me to reach out to Mr. Brunicow, who I believe authored the original PSI, to have an update completed? Okay.
Yes, please. And then that information, once that's completed, will be sent to Mr. Dick, and he can review that with Mr. Wadeski, and we'll have the sentencing date once that's been, or we'll set a sentencing date and allow that process to occur. Mr. Wadeski will be remanded to the custody of the sheriff.
Judge,
That's all for today. Thank you.
I got one housekeeping, Judge.
Go ahead, Mr. Hamlin.
With respects to his fines, I'm not going to ask about circuit court. His balance there is at $991, but his drug court fine currently stands at $390. He's got an outstanding balance at work camp at $73. With the dismissal, which way would the court like to proceed with his drug court $390 fine?
I would like you to give that information to the pre-sentence investigator and include that in any potential recommendation for use at the time of sentencing. And I'll make that decision then so that Mr. Dick has an adequate opportunity to understand what those dollar amounts are and can make any arguments that he wishes to make at that time.
Thank you, sir.
All right. That's all for today. Thank you very much. Good luck to you, Mr. Wadeski. Can I have your name, please, ma'am?
It's Kaylin Petty Hofstetter.
All right, Ms. Petty Hofstetter, my name is Judge Hesselink. I'm here to arraign you on a extradition warrant out of the state of Indiana. Let me call your case and we'll get started on that. This is the matter of the state of Michigan versus Kaylin Petty Hofstetter, file 26-44610-EX-3. Ms. Hofstetter, I'm going to read to you the paperwork, and then I'm going to hear from Mr. Brown, who's the attorney, private attorney that assists the court and at arraignments. Also with me today is Aaron Fortier from the prosecutor's office. The fugitive from justice warrant against you reads as follows. It says that on or about May the 28th of 2026 in the city of Gaylord in Otsego County, that you did commit the offense of a fugitive from justice in that you were charged in Wells County, Indiana, with the extraditable crime of unlawful possession of a syringe and unlawful possession of anabolic steroids, and that that the complaining witness in that case has probable cause to believe and suspect that you are a fugitive from justice and have fled from the aforementioned state, and that you are now found in the city of Gaylord. Well, let me finish reading it to you, and then you can tell me what you want to do with it.
You're fine.
You are now found in the city of Gaylord, county of Otsego, state of Michigan, and are liable by the Constitution and laws of the United States and of the state of Michigan to be delivered over upon the demand of the governor of that to the complaining state to be removed to that complaining state. This is a charge in Michigan which is used to hold a person who has a warrant out for them in another state. Our law does not actually have a penalty for that, but it's used as an administrative way of holding you until we can determine whether or not you are to be returned to the other state. As I understand it, Wells County, Indiana has a warrant out for you on the felony charges of unlawful possession of a syringe and unlawful possession of an anabolic steroid. They also have some misdemeanor cases filed along with it, and that was done in September of 25. You have the right to have a hearing on that issue, or you could waive or give up the right to have that hearing and ask Indiana to come get you as soon as possible. If you wanted to have a hearing, you'd have the right to have an attorney represent you, and if you could not afford one, we would appoint an attorney for you, and Mr. Brown is here to help me with that process. At that hearing, the burden of proof would be by beyond a reasonable doubt, would be on the prosecution to prove not that you're guilty, but simply that there is a felony warrant for your arrest and that you are the person that's charged in that case. So they do not have to prove that you are guilty of that offense. They simply have to prove, number one, that there's a warrant, and number two, that you're the person that they're looking for on that warrant. If they can do that, then you would be held until the time as the Indiana police could come get you and bring you back to Indiana, where you could contest that case as to whether or not you were guilty. If you wanted to have that hearing, you'd have the right to see, hear, and question all the witnesses at that hearing. You'd have the right to get a subpoena from the court to present any witnesses or evidence that you wanted to present. You could testify, or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. As I mentioned before, the burden of proof would be on the prosecutor at all times, and you would have the right to appeal. Do you understand all those rights that I've just given to you?
Yeah, yes.
Do you have any questions about any of those rights?
No, not about the rights.
All right. Mr. Brown, have you had a chance to speak to Ms. Petty Hofstetter about her right to an attorney?
I have, Your Honor. She actually did request an attorney, but I'm not exactly clear if she really understood what I was saying. She would have a right to an attorney in Indiana, but an attorney here she would clearly have a right to as well. But I think it would be of good import for her to know that her husband actually did sign the waiver, that all they really have to prove is she is who they're looking for, and they have a valid warrant, which I did explain to her. So if we could go into a little bit more about that. Honestly, I don't believe she would require a Michigan attorney to help her with this. It would be my understanding she would probably sign that waiver. Again, I did try to explain the process to her. It was a little difficult for her to understand.
It's a difficult process, and I'll grant you that. So, Ms. Petty Hofstetter, as I've tried to say before, you have the right to have an attorney here in Michigan, but all that attorney is going to be able to do is ask for a hearing at which the prosecutor would have to prove that there is a warrant charging felony offenses in Indiana, and that you are the person that they're asking to have brought back to Indiana. Those are the only issues that Michigan has to deal with. You have the right to have that hearing, and I would appoint an attorney for you if you want to do that. Mr. Brown is correct. Your husband was just in front of me a few minutes ago. I went through the same information with him, and he signed the piece of paper that says, Indiana, come get me, and I'll decide what to do about that charge once I get back to Indiana and can fight the entire case, because you can't fight that here. What would you like to do today?
I guess I'll have to sign the waiver.
You know, if it helps, Mrs. Hofstetter, I am actually, Mr. Gauthier did send me a copy of the warrant. It appears to be a valid warrant.
Okay. I mean, I didn't even know I had a warrant.
Well, and that's not unusual. So I'm not saying
because we wouldn't have came all the way up here.
Yep, and I certainly understand that. It would be a surprise to anybody to find out this way. But this is the process.
We were trying to get our life together.
This is the process. Yep, this is the process for doing that. If you want to look at the paperwork, you're more than welcome to do that. The waiver or the form that allows you to be taken back to Indiana, let me read that to you just so that you can understand what that talks about. So the
Okay.
form would say your name,
Thank you.
that you are, so it would say Kaylin Lee Nell Petty Hofstetter. I am the person wanted by the Weld County, Indiana, on the charges of unlawful possession of a syringe and unlawful possession of anabolic steroids or possession or use of anabolic steroids. And that I waive the issuance and service of a Michigan governor's warrant and all other procedures incidental to extradition proceedings, including the right to an attorney unless I've already attained one. And I voluntarily agree to return to the demanding state in the custody of the agent of that state. Do you have any questions about that form?
No, sir. No, Your Honor.
What would you like to do then? Would you like to have a hearing and an attorney, or would you like to sign the waiver and return to the state of Indiana?
I guess I'll just sign the waiver.
All right. Deputy, do you have a form there filled out for her as well?
Yeah.
I do. Sign it right here.
All right.
All right.
Right here.
Go ahead and sign that, ma'am.
Date and sign.
Okay, gotcha. This is what,
Today's the 29th.
29th. Yeah, I've never even been in trouble before, so this is crazy to me. I don't even understand what's even happening.
Well, again,
the only-
Mrs. Hofstetter, it is going to be something that you can deal with in Indiana. Michigan really
Right.
doesn't have.
Can't
any
really do
other-
anything here. I understand.
Right. So we're going to send you back to Indiana where you're going to have all of the criminal rights that you would normally have in a criminal case against you, including the right to have an attorney, the right to have a trial, and the right to question witnesses. All of that you will still have. Today is only whether or not we get to send you back or whether we have to wait and have a hearing before we can decide whether to send you back. Any other questions that you have, ma'am?
No, no, Your Honor.
All right, that's all for today. The jail will notify Indiana that you and your husband have both signed those forms, and Indiana will then make immediate efforts to come get you as quickly as possible. Thank you very
Okay.
much, ma'am. That's all for today.
All right, you guys have a good day.
All right, good morning, Mr. Flory. Up next, we've got Moran v. Bishop, file 24-9092 NZ. Counsel, you want to state your appearances beginning with plaintiff?
Good morning, Your Honor. Sandy Jasinski appearing on behalf of plaintiffs Thomas Moran and Moran Ironworks.
Good morning, Your Honor. Adam Flory appearing on behalf of the defendant.
All right, we're here for a status conference. We have a jury trial on damages beginning next Monday. I have gone through the jury instructions from you both in detail, and I've got several specific questions about those. But first, maybe we should resolve the motions that are up. We had plaintiff had a motion regarding deposition, but that motion was withdrawn. Is that correct, Ms. Jasinski?
Yes, Mr. Berger's motion to compel was withdrawn. He appeared, we concluded before 2 o'clock, and his counsel reimbursed plaintiffs for the costs associated with the earlier cancellation. Very honorable thing to do.
All right. Was that Mr. Coleman?
Yes, it was.
Yes, I find him to be a very honorable man. All right. We also have a motion by the plaintiff to correct a clerical mistake in the default judgment. And I've reviewed Mr. Flory's response that was filed very recently, and indicating no objection to that. So, Ms. Jasinski, do you have a proposed corrected judgment? Is that correct, Mr. Flory? You have no objection to that motion?
Yes, Your Honor. The only that I can obviously only stipulate as to the form, not the content.
Sorry, I'm having a hard time making you out. I'm not sure how great of a record we're going to make. You sound like you're in a tunnel or something.
I apologize. I'll try to, perhaps I can sit closer to the microphone.
Okay.
Your Honor, is that any better?
I think it will be, yeah.
Your Honor, I just said for the record that I don't have an objection, and I just said that I can only stipulate to form and not content.
Sure, yeah. I mean, the defense position and objection to the entry of the default remains preserved. This is just a correction as to the form.
Correct, Your Honor. I provided a stipulation to Mr. Flory, which he declined to respond to until a few days ago. There were two exhibits that were attached to the motion that I filed. One was a proposed corrected order. The other one was the stipulated order that Mr. Flory had an objection to as to the term as to content. I have the copies of the corrected order that was not in a stipulated form that I can present to the court for entry. It was attached as an exhibit to the motion.
Oh, it was attached?
Yes, it was. I believe it was there were two exhibits. I believe this was the second one.
And Your Honor, obviously I can't see the paper. I trust that the court's executing the order that's fixing a clerical error, obviously.
All right, I'm signing Mr. Zinski's proposed order, tendering it back to Mr. Zinski for filing with the clerk's office, and you can get trues and all of that when we're done. All right, and then we also have the plaintiff's motion in limine to exclude testimony or evidence regarding the First Amendment. I did also this morning receive a fairly late filed response to that motion. I don't know if you received that and had an opportunity to review it, Mr. Zinski.
I did receive it when I woke up at 7 o'clock this morning, or 6 o'clock this morning, Your Honor.
Okay. All right, so go ahead and argue anything with your motion.
Your Honor, thank you. The position that we have in the motion in limine, I think, is even more emphasized and highlighted by the response that was filed late or early this morning, actually, by defendants, and was made a concern by virtue of what they argued in their trial brief. And their trial brief is like, this is what we expect to prove at trial. This is the witnesses we expect to call. And what was clear is that they're trying to relitigate the issue of liability in this case. Your Honor, when we start next Monday, it is a damages only jury trial. Liability, and including the constitutional default standard, has already been decided by virtue of the entry of the default judgment. What they are trying to do in this case, by stating that they wish to argue that their First Amendment rights are going to be suppressed, or that plaintiffs are trying to put them off the air, that is a backdoor attack on the default judgment. They can argue, Your Honor, that the harm is minimal. They can do that. That's fine. That's not a constitutional issue. What they can't argue is they have a constitutional right to avoid damages. And clearly, that is what they intend to do.
Well, can I ask you though, I mean, I in large measure, agree with you, but motive is always relevant. And it seemed like in reading Mr. Flory's response, they're saying, well, we're entitled to argue that the plaintiffs haven't suffered any damages. In fact, this lawsuit is motivated by their political opposition to Mr. Bishop. Is that an argument that they would be allowed to make?
No.
Why wouldn't they be allowed to argue that in general without arguing that the statements at issue were protected speech?
Because the words are defamatory per se. What we're looking at is the court has already determined the statements that they made are defamatory per se, were made with actual malice, with reckless disregard of the truth, ill will, or bad faith. Those are the determinations that go into a determination of liability if you're assuming that Mr. Moran is a public figure. That's already been decided. They're trying to go back and then frankly confuse the jury and make this into some kind of First Amendment free speech issue when it's not, because of the default judgment. What they can argue, again, if the damages are minimal, Mr. Moran, has Moran Ironworks lost any contracts? Mr. Moran, let's talk about the mental anguish, the distress, the humiliation, the outrage that you experienced. But going to say, well, really the only reason he filed this lawsuit was to put him off the air, that's irrelevant in defamation per se, and where there's been a determination of a default judgment of liability. That's all rolled into it.
Okay.
Again, what they're trying to do in the silence us thing is to interject issues with the jury that are not relevant. and would confuse the jury. This court, by virtue of the default judgment, has already made the determination that they are liable. So now what we're talking about are money damages and the extent to which the jury should award money damages, in what amount, and how to allocate it between the two defendants. It's the only thing that the jury needs to decide. That's it. Their efforts, again, to try to argue that somehow a jury award would be chilling on free speech rights, that's a constitutional issue that's off the table by virtue of the judgment of liability that's already been placed on record in this case. This is no longer a case, Your Honor, about whether defendants had the right to say what they said. It's about the damage that caused. And when they said something that the law has already determined, that this court has already determined that they knew was false.
Anything else I need to know to understand your position on that?
No, Your Honor, unless you have any other questions. That's our oral argument in connection with the motion in limine.
Okay, thank you. Mr. Flory, your response?
Yes, Your Honor, thank you. Your Honor, I think the court hit on a salient point. Your Honor, can the court hear me okay?
Yes.
Thank you, Your Honor. I think the court hit on a salient point when it questioned Ms. Jasinski there. Here's the issue. Your Honor, we can argue alternative theories as to why Mr. Moran is continuing to propagate this lawsuit. And Your Honor, it goes to the issue of, well, because it's a logical thought of, you must be pursuing this because you've been damaged. You've been damaged and you want reimbursement or recompense for that damage. But Your Honor, that's not the case, and that's what we intend to argue. Mr. Moran has a fundamental opposition to Mr. Bishop and his point of view, his political statements, and that's why he's pursuing this lawsuit. It goes directly to the issue of damages. Your Honor, we are aware that Mr. Moran has made statements to folks in this case, I shouldn't say in this case, potential witnesses, that he did not suffer any damage and that he's pursuing this lawsuit because he wants to, quote unquote, get Randy off the air. So again,
well, the first part of that, you know, that you can present some witnesses that Mr. Moran and his business did not suffer any damages. Obviously, that's you know, admissible and that's the proper subject of the trial. But the second part about that he's only doing this to get him off the air, I do wonder about that. Let's say this was not a defamation case, but an auto negligence case, and Mr. Bishop T-boned Mr. Moran and was at fault for the accident. We're having a trial, and let's say there was a default. We'll try to make it apples to apples here, and we're having a trial as to damages. Would it be proper for the defendant to say, well, gee, they're only suing me because they don't like me. We're political enemies. It just strikes me that that's not really, that's sort of a confusion of the issues. When the question is liability is established and we're trying to ascertain, did the plaintiff suffer any harm or not?
Your Honor, if I may, I think the difference in, I'm sorry, Your Honor, I just got some feedback. I think the difference in those two examples, Your Honor, is that in the court's hypothetical, that's a negligence issue where it's not intentional conduct. In our issue, Your Honor, my client's not being accused of negligence, number one. Number two, Your Honor, in a case where my client T-boned the plaintiff, the damage to some degree, Your Honor, would be manifest. You know, obviously under that scenario, there'd be medical records and testimony of that nature, Your Honor. But Your Honor, it's axiomatic generally that if you're T-boned with any force, you're going to suffer some kind of damage. Whereas in this case, whenever we're talking about damages or words only, excuse me, I have to say whenever we're talking about defamation or words only, damages are much more amorphous. So, Your Honor, damages are not manifest based upon what's been established alone. So again, Your Honor, this goes directly to the question of why would Mr. Moran be pursuing this action? So there's one obvious answer to that. He's been damaged. He's been damaged significantly, and that's why he's pursuing it, because he thinks he's entitled to recompense. We don't feel that way, Your Honor, obviously, but that's a logical position. And so, Your Honor, we have the right to say you've not been damaged. So the next question then, if I'm the jury, is, well, if he's not been damaged, why is he still pursuing it? Yeah, of course, he must have suffered damages. Otherwise, he wouldn't be paying his lawyer and still pursuing this case. No, ladies and gentlemen of the jury, he's pursuing this case because of his opposition to the content of Mr. Bishop's speech. not because he's actually suffered damages. So I don't think it confuses the issues, Your Honor. I think it clarifies the issues. And it provides the jury with a very, very viable alternate theory as to why Mr. Moran is actually pursuing this action. So
can I ask you, how would it be possible to present your theory without arguing to the jury that the defamatory statements were protected First Amendment speech?
Your Honor, when I was trying to pin the court and I accidentally muted the court in the middle of the court's question. So I heard everything except how would it be possible to.
Okay. So let me ask you again, how would it be possible for you to present your proposed theory of the motive for the lawsuit without arguing or implying to the jury that the defamatory statements at the heart of this case were protected First Amendment speech?
Very simply, Your Honor, I can do it with a question right here. Mr. Moran, you don't care for Mr. Bishop, correct? Mr. Moran, you don't agree with Mr. Bishop's political persuasion, correct? Isn't it fair to say that your vehement disagreement with his political persuasion is motivating you to continue this lawsuit, and it's not because you suffered damages? Your Honor, that doesn't address at all protection. That addresses only the true reason for why Mr. Moran is pursuing this action. So, and again, Your Honor, I would go back just the basics of the law we're talking about here, MRE 401, 402. As long as this evidence is relevant, it has to be admitted unless it's excluded under 403, which is a very high standard. 401 is a very low standard, 403 is a very high. I would submit respectfully, Your Honor, that we're talking about two questions. Number one, is the evidence relevant? Number two, if it is relevant, is it substantially outweighed by one of those identified, I'll call them evils in 403? I think, again, Your Honor, under that modestly deferentially low standard set in MRE 401, any tendency to make a fact in evidence more or less probable. A fact in evidence in this case is what of the damages or lack thereof suffered by the plaintiffs. The fact in evidence to make it more or less probable is that you're pursuing it because you have a fundamental disagreement. Your Honor, these are statements Mr. Moran has made. He's literally said, I didn't suffer any damages. I just want to get him off the air. And so, Your Honor, again, if we're not allowed to present that evidence, the jury's going to naturally wonder, well, I can't believe he pursued this unless he suffered some damages. He must have suffered damages. So, Your Honor, I certainly think it meets that deferentially, modestly low standard of relevance. It makes the issue of what damages has he suffered more or less relevant, or more or less probable, excuse me. And in this case, less probable. And it's less probable because he has a reason, namely his distaste for my client's political views, as a motivating factor to pursue this action. Down into 403, Your Honor, confusion of the issues, unfair prejudice, cumulative nature, the court's aware of those matters identified there. I think the only one that's been identified is confusion of the issues. And again, Your Honor, number one, it only confuses the issues at all. Number two, even if it did, which I don't think it does at all in any way, it would have to substantially outweigh that probative value. And again, Your Honor, in this case, we're not presenting that speech was protected. We're presenting that Mr. Moran dislikes the content, and that's what's motivating them to pursue the action. So I would state again, Your Honor, of the example I just, Mr. Moran's a party opponent. I'm going to be able to ask him, Mr. Moran, isn't it fair you said that you've never suffered any damages? Isn't it fair that in that same conversation you said that you're only pursuing this case because you want to get Randy off the air? Didn't you say that, sir? Your Honor, those are very proper questions. And that would be incredibly prejudicial to us if we weren't allowed to pursue those actions. So that's not going to liability. That's not going to whether the speech is protected, Your Honor. I don't think it comes close to being substantially, emphasizing substantially outweighed by any kind of confusion or any other thing identified by MRE 403. So, Your Honor, it's relevant under 401. We should be allowed to pursue that issue.
All right, thank you. Ms. Flory, or I'm sorry, Ms. Jasinski, any rebuttal argument?
Just a couple of points, Your Honor.
Mr. Bishop and Michigan Broadcasting have, since the beginning, tried to characterize this and Mr. Moran's lawsuit as a slap lawsuit. It's not. And in fact, while Governor Whitmer did sign legislation providing for such a remedy, that remedy did not go into effect until March of 2026. So the issue of what Mr. Bishop and his wife's company are trying to prove is completely irrelevant to a defamation per se claim at the time that it was filed by Mr. Moran. What Mr. Flory stated, which is frankly shocking and to me reflects that he does not understand the true nature of the defamation claim here, is he said, these are words only. Who cares? Who cares? Big deal. You know, sticks and stones. Problem is that the Michigan statute 62911 specifically recognizes, as the jurisprudence of this state has for a very long time, that certain words do matter and constitute defamation by themselves.
Right, and I agree with all of that. Here's the only part I'm struggling with your motion is the way Mr. Flory just formulated a hypothetical line of questioning. If that were the only thing that the defense was going to do, I do have a worry that they're going to get into all sorts of other stuff, as evidenced by, frankly, their proposed jury instructions as well. And I'm not going to allow that. But if it was, so what if I were to grant all your relief except for allegations of retaliatory motive? Help me understand why that should be excluded. The simple line of questioning. Didn't you, assuming he has evidence of this, that didn't you tell somebody that you weren't really harmed, you just want to get him off the air? That seems to me fairly relevant without making it, without undermining the default.
Well, if he wanted to get him off the air, for what reason? Because they're on free speech rights, opposite sides of the fence. I think he's going to, I mean, if the
well,
opposite.
Because he lied about me, right?
Well, yeah, he lied about me. There's that. There's that. Or you're not only that you lied about Thomas Moran and Moran Ironworks, but that you accused them of violating federal immigration statutes and essentially running a criminal enterprise in their business. Yeah, that's a reason that you might file a lawsuit against someone for defamation per se. And defamation per se, those words themselves are presumed to create harm.
All right, thank you. Well, in this case, it's a defamation case. A default has been entered on liability. So all well-pled allegations are true and jury will be so instructed. And the defense trial brief and proposed jury instructions seem to want to reopen all of that. Some of the defense jury instructions were even as to the elements that have already been established by default and telling the jury what the plaintiff has to prove to establish those elements. And in the trial brief, all of it seems cut of a cloth that the defense theory is to try to make this, you know, a very political trial and get into, you know, this is a disagreement about Mr. Bishop's free speech rights. It's a close call because I think Mr. Flory makes a fair point that in general, you know, the motive of the plaintiff in bringing the suit might well be cross the minimal threshold for relevance. So it's not that that's irrelevant. Much of it is the First Amendment stuff. That's all irrelevant because the default is it's not a fact for the trial. But the motive is a relevant fact as to damages. So it clears the 401 threshold. I am concerned about the 403 balancing the danger of unfair prejudice and particularly the danger of confusing of the issues. This is a tricky enough needle for us to thread with this jury. My review of the trial brief and the jury instructions shows that the defendant is not particularly interested in threading that needle for us, but just trying to make it about the issues that have already been defaulted and make it about the First Amendment when it is not. The fact The allegation that the statements were false and that they constituted defamation per se, that a retraction was not made, and that it was made and that the defamatory statements were made in bad faith. Those are all established facts for this trial. Those facts will not be submitted to the jury to decide. They've been decided by default. And to bring in the issues that the defense wants to bring in about the political disagreement between these folks, I think the relevance is not high, but the confusion for the issues is very high. That's a very real danger that this trial is gonna go off the rails into a trial about Mr. Bishop's right to say what he wants on his radio program, and that is not what this trial is about. So on the 403 balancing and in the exercise of the court's discretion, I'm going to grant the motion in limine in whole. And Ms. Jasinski, do you have a proposed order to that effect?
So, Your Honor, may I ask a clarifying question?
I'm sorry, go ahead.
May I ask a clarifying question?
Well, you know, every time you ask that, you end up wanting to argue with me about my ruling. So you may ask a clarifying question. What you may not do is make further argument. So ask a question to clarify the ruling if you have one.
Well, first of all, Your Honor, with respect, I respectfully take exception to that. I don't believe I... All
right, stop. I told you, when I make a ruling, every time you say, can I clarify? And then you argue with me about my ruling. So no, you may not ask the question. I even told you, ask a clarifying question. And you start out by saying you take exception to it. That's not what that's for. So we're done with that issue. I have the proposed order in front of me. I'm signing it. You can read the order, and those should answer all your questions. I'm tendering it back to Mr. Jasinski.
Thank you, Your Honor.
All right. So now that brings us to, well, I mean, I did receive at 1:30 in the morning, the court did receive an emergency motion to compel a deposition. It doesn't have a notice of hearing with it. Did you want to address that in some fashion today, Mr. Flores?
Yes, Your Honor, thank you. I'm happy to notice if the court would allow hearing date to provide that, Your Honor, I'd be happy to notice it for a hearing. The other thing I would say, Your Honor, is under MCR 2119A1, a motion is not required actually to be in writing or to be brought to a hearing, and so it can be brought orally at the time of a court hearing. And so I would also do that here at this time now, Your Honor. Your Honor, the motion is, and the subject matter of it is very simple. I'm not sure if the court would like for me to go into any argument at this time.
I mean, I read your motion. It seems that, you know, you want me to compel the plaintiff to appear for a deposition sometime this week because he's evaded your efforts to take his deposition to this point in time. Am I understanding your motion right?
Yes, Your Honor.
So my question for you is, isn't that kind of too little too late? We're 7 days before the trial, and discovery's long since closed, and this is the first time you're coming to me and asking for help with that issue. Isn't it incumbent on you to come to ask about this? I mean, you've attached emails from back in September where you're having troubles with this. You know, that's like 9 months ago. So months and months and months go by when you're trying to take the plaintiff's deposition and unable to do it, and you file a motion at 1:30 in the morning the week before trial and you want the judge's help. Which judge in the state of Michigan would do that for you? It's not going to be me. The motion's denied. All right. I do have some issues about the jury instructions. Overall, I'm planning to give the plaintiff's proposed jury instructions for several reasons. They're in a more readable format in terms of font and spacing. They more accurately reflect the court's prior default and spoliation rulings. And also, defendants' proposed jury instructions were sometimes out of date. They seemed to use either the prior versions of the model instructions or incomplete versions. So the plaintiff's proposed jury instructions are overall much more preferable. We'll seat 2 alternates, so we'll seat 8 jurors because we have several days going. There's, in a civil case, each side is only going to have 3 peremptories, but I did want to tell, although I'm going to take pains to try to prevent the trial from becoming political, because both sides have a well-known personality or business. We have summoned extra jurors. So it is my practice to allow the lawyers to lawyer a bit during voir dire, and I'll let you guys explore those issues on voir dire about, you know, bias or prejudice or whatnot. And you know, we're hoping to bring a bunch of jurors so that I can be. Sometimes judges are not very forgiving on challenges for cause, so I'll try to be a little more forgiving on those issues so that we seat a jury that is going to be fair to both sides. All right, so specific questions about the instructions. 2.14 reference documents was requested by plaintiffs about giving the jurors a binder of the transcripts of the broadcasts. So I presume you're going to have those. What is that about?
The court anticipated some questions that I had for the status conference, and recently I had the pleasure of seeing David Byrne from the Talking Heads in concert, and so my question was notebooks. What good are notebooks? So what we were hoping to have with the juror notebooks would be the first amended complaint in the copy of the transcripts that are the subject of the trial. Those transcripts were verbatim in requests for admissions. And so we could probably to include those transcripts, because we anticipate also that we're going to be playing the broadcasts themselves that are the subject of the lawsuit, so they can like follow along, listen and follow along if need be.
Okay, and so you are requesting the 2.14 for preliminary instruction?
Yes.
That was only about the reference documents. I'm not sure that giving them a copy of the amended complaint, that usually doesn't happen. I mean,
whatever the court's preference is.
Okay, and your requested jury instruction was just as to a binder with the transcript of the broadcasts. Mr. Flory, what's your thoughts on that?
Your Honor, I personally would not be in favor of that. I think that we should just have exhibits admitted in the normal course, and then they can be published to the jury as appropriate.
Yeah, so I guess, Mr. Zinsky, what's wrong with just, I mean, obviously you'd get those introduced as an exhibit, and then they can be published to the jury and available for them during their deliberations. What is it about those that make it necessary to put them in a binder that all the jurors have at the beginning of the trial?
Just for their convenience, in order to be able to look it over, review it, and particularly if they're, you know, listening to the broadcast, if there are any problems with the audio. It's purely a matter of convenience, Your Honor.
Okay, I mean, there's certainly no prejudice. They were deemed admitted, I think, by prior order, and you know, they're the heart of what the statements were. It seems would be helpful to the jury, so that they don't have to wait until the end of the trial or the middle of the trial to know even, well, what are we really talking about here? So I'll go ahead and give 2.14 as requested and allow for those reference documents, but they're limited to the transcripts of the broadcast, not any pleadings in the case. And then in the preliminary instructions, the plaintiffs did have three proposed special jury instructions about the default and its effect on the case, spoliation instruction, and the defamation and the definitions of defamation. I didn't receive any specific objection to those. They seem to me to be accurate based on the law and tailored to this case and its procedural history. But Mr. Flory, so we're not sorting this out on the day of trial, I wanted to hear from you if there were any issues you had with those special jury instructions in the preliminary instructions.
Yes, Your Honor, I vehemently object to those. I do not think they should be included. I think that the standard instructions should be included, Your Honor. Perhaps the spoliation instruction may be relevant depending upon the evidence that comes in, Your Honor.
Well, is there a standard jury instruction to tell the jury there's been a default and here's the effect of it in the case? I don't think there is one.
I don't think they need to be told that specifically, Your Honor. I think the jury needs to be told what issues they need to consider. And so that will be done through the damages instruction. So if I may, Your Honor, so that's my response to that question. Again, I think it's part before the horse with regard to spoliation instruction. We don't know what impact until the evidence comes in. We don't know what what the impetus of that is going to be. And so I think that should wait until finals, Your Honor. I don't think that goes in preliminary anyway.
Well, except that I already entered a ruling that they're entitled to a spoliation instruction. So maybe my ruling is wrong and the Court of Appeals will agree with you that it's wrong, but having already made that ruling, shouldn't I instruct the jury as I've previously ruled that I would?
Your Honor, I don't know the court's order in front of me, so I apologize, I may be mistaken. My memory of the court's ruling was that it would give a spoliation instruction if warranted. And so I think it
was that they get a spoliation instruction and we'll have to sort out this precise wording, as we get to trial. So plaintiff presented one, defendant hasn't. The defense objections to these special instructions seem to be, again, some backdoor effort to try to reopen issues of the case that are closed. There's nothing that the defense has pointed out in those instructions that are inaccurate, either to the facts or law or procedural history of the case. So I'm going to give those proposed instructions. All right, the final instructions. The defense requested 3.05 that corporations are entitled to unprejudiced treatment and makes reference to plaintiff and defense corporate parties. Any objection from the plaintiffs?
None.
All right, so I'm going to give that defense requested instruction 3.05. 3.06, well, Mr. Flory, you are still requesting 3.05, is that right?
Yes, Your Honor.
Okay, I'll give that.
Thank you.
Now, obviously, there are things that can happen at a trial that affect the final instructions, and we'll talk as the trial proceeds. But just so that my staff is prepared with binders and I'm prepared, I'm trying to sort out what we can ahead of time. The defense also requested 3.06, that it's irrelevant whether a party is insured. I'm not sure whether that's relevant to this case or not. Mr. Flory, why is it that you think that instruction is necessary?
Oh, I think it's certainly relevant, Your Honor. Parties have insurance against that defamation frequently. My client in this case does not. But parties frequently have defamation insurance, often through homeowners insurance. And so it's relevant for that plain reason, Your Honor. I don't think I've ever had a trial and a civil trial. I'm trying to think. I can't recall a civil trial right now where that instruction's not been given. Obviously, I think the risks are obvious. The jury may think that, well, the defendant's probably got insurance, so it's no skin off his teeth if we give an award. And so that's the purpose of the instruction.
Okay, and what's your thoughts, Ms. Jasinski, from the panel?
I was equally as puzzled as the court when I saw that initial jury instruction, because I don't believe that there's any insurance that would cover defamation, but it just didn't seem relevant to this case.
Your Honor, I apologize for everything, but I have a case right now in federal court with a state law defamation claim where the party who's accused of defamation has a plaintiff's lawyer representing them. So they're a plaintiff and a co-defendant. So they have a plaintiff's lawyer representing them on their plaintiff's claims, and then they have a separate, different lawyer representing them only on the defense of the defamation. And that's because they have insurance for it. Your Honor, I've seen this many times in my career. Homeowner insurance frequently covers defamation. Not always, but often. Again, I have a case right now pending in the Eastern District where it does. And I've seen it many other times in my career. And also, Your Honor, this is such a pedestrian instruction. I mean, I don't see any prejudice to any party by giving it.
All right. I mean, well, it's a standard instruction, but the standard instruction should be given when they're applicable. The note on use from the Civil Jury Instruction Committee says this instruction is to be used only where the subject of liability insurance has been brought out during the trial. I just don't see how that's possibly going to be brought out during this trial. So unless somehow that does come out during the trial, it will be my intention not to give that instruction because it just injects an issue that isn't really in the trial. So I'm going to defer to the use note and not give that unless evidence does come out in the trial that makes it relevant. Plaintiff requested 3.13 facts judicially noticed, requesting the court to take judicial notice and to so instruct the jury regarding the timing of the defamatory statements in relation to items in the national news. I'd like to hear from both sides about that proposed instruction. I have a bit of a concern that it seems potentially inflammatory, but perhaps that's the point, that it could be relevant to the issue of possible reputational harm or damages, that these statements were made in an environment where that it was a particularly volatile issue. The facts in question about the dates that statements were made, publicly reported statements at a presidential debate, they do seem capable of judicial notice. So I guess I wanted to hear first from you, Mr. Floria, and your position on that proposed. And well, I guess Ms. Jasinski's the proponent of it. Maybe we should hear from her first.
This defamatory broadcast accusing Mr. Moran and Moran Ironworks of basically flying in illegals, a criminal enterprise, was made on September 12th. And in the context of that broadcast, and as the court has seen the transcript has been admitted as authentic. Mr. Bishop posits it this way in terms of people are talking about abortion. That's not the issue. Slotnick is focusing on that. What we need to be focusing on is illegal immigration and how 1 in 6 women are likely to be raped during their lifetime. And it's really going to be by an illegal immigrant. 2 days before he made that statement was the presidential debate where, and there's no doubt and no dispute that illegal immigration is a very hot button topic. 2 days before Mr. Bishop gets on the radio and accuses Moran Ironworks of a criminal enterprise that could result in the sexual assault of the listeners, neighbors, and friends. The president of the United States in a debate, in a presidential debate, comments on illegal immigration problems in Springfield, Ohio, and the comment that those immigrants were eating dogs, eating cats, and eating pets. That was inflammatory in and of itself, but the timing of what Mr. Bishop did 2 days after that only exacerbated that by making those false statements against Mr. Moran at that time, after those comments had been made in a presidential debate, had and did result in additional harm. He amplified those statements with a false statement concerning Mr. Moran and Moran Ironworks. And that's why we would ask the court to take judicial notice of that, to give the jury an understanding of the context historically when those defamatory statements were made shortly after a presidential debate, also discussing the topic of illegal immigration.
Well, I get the point you're trying to make with that, and it may be, a relevant point, but similar to my ruling about First Amendment and the retaliatory motive, I'm concerned here about 403 and confusion of the issues and unfair prejudice that Mr. Bishop is now, being attacked for, or could be attacked for statements that somebody else made.
Your Honor, that is a legitimate point. That is a legitimate point. And if the court is concerned about jury confusion, then we will withdraw a request for that jury instruction.
All right. Well, I think I will. I assume, Mr. Flory, you object to that proposed instruction in judicial notice?
Yes, Your Honor.
Okay. I will. As I said, I understand the point that the plaintiff is trying to make about that, and in a vacuum, it might be a fair point, but I think the risk of unfair prejudice or confusion of the issues substantially outweighs the relevance. So I will not take judicial notice of the presidential debate and statements made there, and will not give the proposed jury instruction 3.13. And frankly, I think unless they're living under a rock, any juror doesn't need to be told specifics to know that immigration and illegal immigration in particular is sort of a hot button issue these days. All right, the plaintiffs also requested 3.16 interim commentary. That seems like it's not part of final instructions, but appropriate to be given in the middle of trial if a commentary is allowed. It's not my favorite practice to allow that sort of thing beyond the traditional opening and closing. So it'd be my intention not to give that unless an opportunity comes up for such interim commentary and I allow it. Any further thoughts on that, Ms. Jasinski?
No, Your Honor.
Mr. Flory?
No, Your Honor.
Okay. Defendant requested 4.06, witnesses interviewed by an attorney. It seems appropriate when requested. Any objection, Ms. Jasinski, from the plaintiffs?
None.
Okay, I'm going to give you are still requesting that instruction, Mr. Flory?
Yes, Your Honor.
Okay, I'll plan on giving 4.06. Again, all of these rulings are subject to, if there's something at trial where this comes up, I'm going to be talking with counsel and chambers at some point during the trial about these final instructions. I'm just trying to get a head start here. 4.11, deposition and deposition summary. The plaintiffs have requested. I guess, Mr. Jasinski, I just wanted some clarification from you about what's your plan with regard to that DeBeniesi deposition, with regard to playing it or a transcript or a summary?
We have, we plan on playing Mr. Gruber's deposition that was conducted via video, and we plan on playing that deposition. We also plan on having excerpts from that deposition, from the transcript itself. Likewise, it is possible, based on the proofs at trial. We have subpoenaed Mr. and Mrs. Bishop for trial, but their depositions were also taken via video as well. And it is possible that we will be introducing excerpts from those depositions as well as extracts from their transcripts.
May I, Your Honor?
Okay. Yes, Mr. Flory, your thoughts?
Your Honor, as to the jury instruction, I think we don't know if it's needed now or not. If the deposition is used, it probably is needed, and if it's not, it's not. As to Mr. Gruber, Your Honor, I may address that issue with the court in an attempt to preclude that from being admitted. I don't think it has any relevance, Your Honor. Mr. Gruber essentially said during his deposition that he had no connection, he had no knowledge about anything in this case. I specifically asked him at his deposition if he had any idea at all as to damages sustained or lack thereof by Mr. Moran, and he did not. So, as I've been politely reminded many, many times that this trial is about damages, Mr. Gruber again testified that he had no knowledge as to that issue. So I don't think that testimony should come in.
All right, well, it sounds like, maybe the 4.11 deposition instruction, which is appropriate to be given at the time that a deposition is played or an excerpt is given during the trial, and also as part of the final packet. Doesn't sound like we can solve that question today, so I'll defer on that until trial and see what shakes out.
Thank you.
Defendants requested 10.01, an introduction to a definitions section. This comes from the chapter on negligence, which has a lot of definitions. In this case, there's not a lot of definitions. It seems kind of unnecessary and from a different chapter. My thought is not to give that instruction, Mr. Flory, as the proponent. Do you want that instruction, and why?
I would, Your Honor. I think it's helpful. I think it's explanatory. I also think it's, I don't think it's a huge issue one way or the other, but again, it's simply an introduction to the definitions, Your Honor. I don't think it moves the needle one way or the other. I think it's modestly helpful to the jury.
Okay, and I don't think it's a harmful instruction, but I don't know that just grabbing the introduction to the negligence chapter is necessary, and this is not a case that has a whole lot of definitions. I don't think it's needful. And I already find that the instructions that I think are needful, the jury does not agree with my opinion about that, and they seem rather bored by the end of the instructions. So I don't want to add to them more than is necessary.
Understood, Your Honor. Thank you.
All right. The plaintiffs requested special instructions on default, spoliation, and defamation definitions. I've already ruled on that I'm going to give those as part of the preliminary packet and also then part of the final packet. The defendants requested a bunch of definitions about libel and slander. These include all of the elements, which doesn't really take into account the default ruling and the effect on the case. They're just given to the jury about, here's what the defendant has to do or what the plaintiff has to do to prove their case as to all those elements. So my thought, Mr. Flory, is that those would not be appropriate because of the limitation of the trial issue to damages. As the proponent of those, do you think those should be given? And if so, why?
I do, Your Honor. I think it's essentially helpful to the jury to understand the case and what the claim's made up of and what we're here talking about. Again, I think it's helpful for the jury to understand what constitutes the claim that's being filed and what my clients allegedly have done wrong. But I would defer. That's my position, Your Honor. We request the instructions be given.
Okay, I'm not going to give those. I think the requested special instructions by the plaintiff fill all those purposes, tailored to the facts of the case and the effect of the default, and they are legally relevant. So the definitions requested by the defense as to libel and slander aren't necessary. And I think the way that they're worded would open up the jury to confusion about what issues they're being asked to decide. All right, so then only 3 more left. We're coming in for the landing here. 118.21 exemplary damages. The plaintiff's proposed instruction takes the default ruling into account. It does seem to me to be narrowly tailored and measured. It seems that Ms. Jasinski has resisted the temptation to write them in a plaintiff's tone. They sound like they're in a judicial tone. The defense proposed instruction, by its terms, would require the plaintiffs to prove facts that have already been established by the default. So I'm inclined to give the plaintiff's version of that instruction. Mr. Flory, I assume you object to that, and anything you want to say about that?
Your Honor, I do respect the court's ruling. We object, as the court knows. I don't, if the court's finished ruling, I'm not going to add anything further. Your Honor, does the court have the number handy? You said it was 118.
Yeah, 118.21, the exemplary damages instruction.
Thank you, Your Honor. Yeah, we would just, Your Honor, I think the court knows our position. We object to it. I'll rest that.
All right, and that objection is preserved. All right. The defense requested 53.05 mitigation of damages. Mr. Flory, as the proponent, what say you about that instruction?
So, Your Honor, I think mitigation of damages, again, perhaps is not the most often found in this context, but it is, I think, appropriate given that that is just a rule that's applicable in all cases in our jurisprudence, that a party who suffers damages has an obligation to mitigate damages. I'll throw one hypothetical example out quickly, Your Honor. If a party who's been the victim, quote unquote, of defamation.
Hang on, pause for a second. I'm having trouble hearing the attorney here, so everybody in the courtroom's got to be quiet or you got to leave. Okay, go ahead, Mr. Flory.
I'm sorry, Your Honor. I'll try to project more. Your Honor, a party, hypothetically, a party who says they're the victim of defamation, perhaps they're suffering some kind of mental anguish. They're suffering some kind of emotional distress. I think the mitigation of damages plays into that context in the sense of what have you done to treat that? Have you gone to see a therapist? What steps have you taken to address that? So, Your Honor, that's just one example. Again, it's well established that all parties have a duty to mitigate damages. Damages are at issue in this case. I think it's relevant. I think it should be given.
Hey, Ms. Jasinski.
Your Honor, I think that the mitigation of damages instructions that he seeks court to allow, again, is a backdoor effort to get to the issue of or to attack the default judgment. And in this case, what the court concluded by virtue of its default judgment is that Mr. Moran and Moran Ironworks, the well-pleaded facts in the complaint, made 2 requests for retraction and that those retractions were insufficient. So this mitigation of damages, that's mitigation in the context of defamation. This particular instruction would, to the plaintiff's way of thinking, attempt to attack the default judgment.
All right, well, the use notes for that instruction say that this instruction should not be given unless there is evidence creating an issue as to whether plaintiff failed to use ordinary care to minimize his or her injury or damage. The hypothetical that Mr. Flory outlined, if that were the facts of the case, may well warrant that instruction. But I'm going to start from the position that I'm not going to give that instruction unless there is some testimony that comes out during the trial that makes that relevant. So Mr. Flory, just take note that I'm not planning to give that in the final instructions. If something happens during the trial where you think it's appropriate, you'll have to re-raise that issue with me, okay?
Thank you, Your Honor.
All right, and the final instruction question I have, the defendants requested 53.06, the effect of inflation on future damages. Seems to me in a defamation case, we're looking at past harm and exemplary damages, and future damages is not an issue. Ms. Jasinski, are you seeking any future damages?
That was a head scratcher for me, Your Honor, so no.
Okay, Mr. Flory, as the proponent, do you think that's a necessary instruction?
If the plaintiffs are on record saying they're not seeking future damages, I think inflation only applies to future damages, so I think that issue.
Yeah, and I don't think that that future damages would really be a thing, and maybe that's encouraging for you to hear that today. But yeah, I think we're looking at past reputational harm and past and present reputational harm and exemplary damages.
I am incredibly encouraged, Your Honor.
All right, the verdict form, the defense verdict form, in it by its terms would ask the jury to decide issues that have already been determined by the default. The plaintiff's proposed verdict form does seem to be accurate and tailored to the procedural posture of the case. So it'll be my intent to use the plaintiff's verdict form. And if you have any specific objections to that, Mr. Flory, we can address that during the trial as things come up.
Thank you, Your Honor. Will the court staff be putting together a final product of the instructions and sending them to the attorneys, or no?
Yeah, well, what I generally do is have the preliminary instructions in binders for the jurors and for counsel, and a proposed final jury instruction available for counsel at the outset of the trial. We don't really do that in a soft copy version. So it's generally my practice just to give those the morning of trial. However, I can see about maybe it'd be helpful if we just have staff scan that in and send it to both of you ahead of time. We'll see about that. It depends on how soon I get that part done and when I get it to my staff. Okay.
Understood.
But we'll see about. I'll try to accommodate that. How about that? No promises, but I will try to do that.
Thank you, Your Honor. And Your Honor, I just want to preserve the record on the deposition issue. I promise I'm not trying to draw the ire of the court. I'm not trying to relitigate the issue.
I mean, I want to allow you to make a record for any review purposes. So go ahead, Mr. Flory.
I'll make it just a couple of sentences, Your Honor. I just want to state for the record that in addition to filing the written motion, I've made the motion here under 2119A1. We've not been allowed to take the deposition, and the court's denied the motion, and we're objecting to that. Thank you, Your Honor.
Okay, very good. Yes, and I feel very comfortable denying a motion to compel the deposition of a party in a case that's well more than a year old, 7 days before the trial. So if the Court of Appeals thinks I'm wrong about that, so be it. All right, thank you. All right, we'll see you all next week for jury selection. I'd like to see counsel in chambers at maybe 8:30, just so we can touch base.
We'll be here at 8 o'clock.
Okay, well.
I'll be there at 7:59, Your Honor.
All right. You guys got to turn even that into a competition. How about that? I'm looking forward to a really fun week with you all. All right.
I can't wait, Your Honor. Thank you very much for your time this morning.
All right, thank you.
Thank you, Your Honor.
Oh, wow. Oh, wow. Oh, wow. I did not realize the crazy nest of things. I thought I had all this. I did have this set up, but everything crashed. Oh, did it again. Here we are. I did not realize the crazy nest of things we were stepping into with the free speech argument and the radio talk show thing. That's cool. That's interesting. You have to look up that radio show. Maybe it's available on YouTube somewhere. That's very much a possibility. Thank you guys so much. It's been 250 minutes straight of court content on the 250th anniversary of this here United States of America, and our celebration of the signing of that there Declaration of Independence. Happy Independence Day, ladies and gentlemen. Thank you so very much for hanging out with me. Hold on. I'm sure there's a whole lot of names here. I got to start some credits rolling, and I got to say a lot of names out loud. I'm gonna read some super chats and that type of stuff because that's what you're supposed to do. Jamargard says she's passively listening, prepping for company. Happy 4th, and thank you for the many hours of content. You're so very welcome. Thank you so very much for your super chat. Happy 4th of July, Stephen. Great to see you again. Vegas Starlight, thank you a million times over. Vegas Starlight dropped a huge donation on us earlier today. Nina, out of the blue, great to see you. The Courtroom Files, Dan, great to see you. Zach, our good friend. Law Nerds Unite. Julie Sassy, here's to life, liberty, and the pursuit of content. Amen to that. Nina out of the blues, dropping some money for some ice cream for milkshakes. Mom, we need to check on the ice cream. And Sally Port, for helping me ban those kids from my room. You're so very welcome. I hope you had a great nap, Sally Port. Veg, I can't thank you enough. I just can't thank you enough. Steven, thank you again. Bat Boy's back, thank you again. Zelda, thank you again. What's all this? Got a lot of jewels, and I can't read everything. It's just not possible. I can't thank you enough. I can't thank you all enough. All right, so here's the deal. Tonight is for fireworks. Even if you're not watching fireworks, watch them on YouTube or something. Tonight's for celebration. We're not doing a premiere tonight, but there will be a premiere tomorrow night. It's an interesting one. It's a Cowlitz case. It's neighbors feuding. The puppies are excited for it. I'm excited for it. You should be excited for it also. We do this kind of thing you're seeing right now every single night of the week at 8 p.m. Central Time, 9 p.m. Eastern Time. And I have premieres on the weekends. I also do this every single weekend at 11 a.m. Central Time. We don't always go for 4 hours. The 250-minute show is strictly for the 250th anniversary of this here wonderful nation of ours. Thank you so very much for enjoying this court content with me today. I am your lone wolf Usul. I can't say thank you enough. It's thank you a million times over. I am your humble host. And for now, I am out. And remember, only you can take a bite out of crime. Bye!